హలో హలో
Page wise mention. 1. Item number 4 to 16. Page number 2. Item number 17 to 33. Page number 3. Item number 34 to 51.
39, huh? All right, next week. Yes.
Page number 4. Item number 52 to 67.
38. Yes. You are appearing for the respondents. Have you informed the other side? What after 3 weeks?
Subject to my lords, kind leave, my lords.
The request of the learned counsel for the respondent who undertakes to file vakalat on behalf of the respondents and to file counter just after 3 weeks. 50? 2 weeks, right?
Subject to my lords, kind leave. Items 62 and 63, my lords.
My lords, I appear for the respondents, my lord, in this matter.
Lordships may kindly take it up after 3 weeks, my lords. I have to file
My lords,
The other side,
my lords, I appear for the respondent in this matter, my lords.
no,
My lords, I
even
appear for the.
the other person mentioned
lords-
is also for the respondent only.
My lords, I
Lords, I
appear
am
for
for
the.
the petitioner, my lords. Items 62 and 63, I am for the petitioners, my lords.
Okay. As
Lordship,
yes,
may
the
kindly-
option for the adjournment. Respondents.
3 weeks. My lords, interim orders may be
My lords-
extended, my lords.
My lords, we had filed a rejoinder way back in September, my lords. A counter way back in September, my lords. Only
Not in September,
What date
my lords.
we-
It was in October. Lords, Lordships, may I have due to some personal inconvenience, I could not make it ready, my lords. Lordships may kindly have it after 3 weeks. We will file, my lords.
Alright, this after 2 weeks.
my lord, last because
My lords, interim orders may be extended, my lords.
my lords may indicate as the last opportunity because there is interim order against me, my lords. Humble request, my lords.
It's after 2 weeks at the request of the Learned Counsel for the petition to file a rejoinder to the interim order granted till then. Yes.
And this may be last opportunity, my lords. They have taken 2 dates, my lords. Humble request, my lords.
Alright.
I am for the respondents.
They have not.
Because the
filed
interim
petition,
order
but
against
they
me,
have
my
lords.
non-satisfied.
Page
Item
number
60.
5.
Obliged.
8 to 83. Page number 6. Item number 84 to 99. Page number 7. Item number 100 to 114. Page number 8. Item numbers 115 to 129.
Up to 129, anybody else? Any 124, 5. It's not going to reach today. Day after, we'll see them. Yes. 120? Yes. No, no 230 matters. Yes. What is the urgency for 230? You should tell me what is the urgency. What is the urgency? Before even making mention for 230, should tell me the urgency. If there's no urgency, you should never mention. Yes. It will be coming Thursday. See, all those matters, unless until it is urgent, other matters which you want to be listed, you please give it to my court officer, he will get it. 131, you want adjournment? What is urgency? No urgency. Yes.
Item 158.
All right.
Item 158. Matter pertains to suspension. In fact, in similar case, your lordships are granted interim order also. Suspension more than 7 months.
We consider the when it reaches. Whenever it reaches. transfers are going on. What is that? The second week.
Question on the same issue on the grade one service plan regarding pension and benefit of pension benefit quality covered at George. A similar matter has been filed on the day and the report is passed election. The urgency is that they have got an appeal election and being deprived in representing the appeal. That is the only study lordship. If matter is heard and
Who has gone in appeal? There is an interim order in your favor.
not in this matter, lordship. This is the matter after the matter, a judgment has been passed after court in a similar matter. A fresh matter has been fixed and come up for this court. And the lordship has passed an interim order subject to the appeal. They have already filed an appeal. In my matter, there's no interim order passed or it doesn't come for its final hearing. The third clears my matter once it passes some order. I not be deprived.
Then fast when it reaches. Yes.
Your lordship, it is not in the list.
Then list it. Put it in the list.
Okay.
Second week of November.
Petition also for 905. One, it is the recently transferred this one, but we are giving the indicator. This is the today is the district. I'm still.
It's in the onwards list.
Date, madam, add అవుతుందని ఇది పక్కన చేశారు.
They'll be added to the list. They'll come.
Employment is fingering. It was urgent and for instance, and till now it has been not been listed actually from last month.
Student, verify change. Yes.
Motion list, item number 1, for withdrawal, Pawan Kumar, Chief of Roads and Buildings, Ravi Babu.
1 and 2 saying?
My lord,
Yes, sir.
my lord,
Yes, sir, Mr. Anantrao garu cheppandi.
my lord, a dependent pension, my lord, case may be added to the list, my lord. 23872 by 2021, my lord.
All right.
Disabled child, my lord.
All right,
asking
it will
for
be added to list. Yes.
some date may be given.
Will,
Next week.
the second week of
date,
November. We added to the list in the second week of November.
much
Yes.
obliged.
Yes, the then counsel for the petitioner has filed a letter stating as under. In view of the above, the resolution is dismissed as withdrawn with liberty as read. Yes, next. On the same.
Item number 3, Sai Prasen, Ravi Praveen Kumar, Megharani Agarwal.
There is no liberty played here. My client is intending to withdraw the above reparation. That's it. No liberty is sought for in the letter. For what? New cause of action, always liberty is there. Why do you need a liberty? On the very same set of facts, you want to file a fresh reparation, you cannot. Because nothing is mentioned here as to why you want to withdraw, except the prayer of the reparation. And then you want to withdraw.
Yes.
Direct counsel for the petitioner has submitted as an. However, the petitioner is at liberty to file a fresh petition if a fresh cause of action arises. So if a fresh cause of action arises, I have given you liberty to file a petition.
Item number 4, Gopal Rao.
Education is working as inlet plant attendant. But after acquiring the qualification of MSc, my chemist he made a case 20 naked. Case 20. I made a representation. Since the similarly placed persons were not appointed by transfer as chemist, I made a representation on 30th August 2022. followed by subsequent representation also page 21. But
You are now appointed as what?
appointed to the post of appointment by transfer
No,
to the
what-
post of chemist,
No, you are working as JPA means
with a junior plant attendant.
junior plant attendant.
Yes, I acquired the qualification of MSc in the chemistry department. I passed in first division. But since the persons who are similarly placed persons were appointed by transfer as chemists, but I too made a representation.
But you have not referred to any similar circumstances in your
The
representation.
similar proceedings I have filed at page 35.
But in your representation, you have not mentioned.
But representation doesn't,
Not then.
but subsequent representations, but the latest representation also, I find it was forwarded also, page 25. Page 25. Let them consider my representations and pass office, but as was done in case of similarly placed person. Page 25.
Yes, who is appearing for the respondents?
My lords, this is Suresh Kumar on media on behalf of my lords.
Yes,
My
please.
lords, I'll get instructions, my lords. The representations, why the representations were not considered, and other similarly situated persons, I have to get instructions, my lords.
Let them consider and pass all this, but that's all I must.
100. When do you want? How much time do you want?
1 week, my lords.
Next Monday. At the request of the standing council, Ms. Uma Devi to get instructions in the matter. Monday in motion, adjourn motion.
Oblige.
Number 5, Suresh Kumar, Chief of Services.
Hmm.
For the next notice issued by the PSW, verification number.
So, what is your right to be selected? Did you qualify in the written examination?
We got the petitioner's master as per the, that he has having qualification of degree, any bachelor degree. But we also got the marks which are required, which was the examination to connect with. And even though getting the cutoff marks, he also got sufficient marks, but still he was not qualified.
Yes. At the request of the special GP for home to get instructions in the matter. Next week. Next week in adjourn motion.
Item number 6, Chandra Sunkara, Ragopal, Chief of Services.
Coming for a fresh admission. Who has filed counter, what we call it? Huh? I think similar matter is there maybe. Master key question number 46, 57, 59. Which examination is this? Who is appearing for the respondents? What happened? No GPs today? You are here. Okay. Who is appearing for the respondents here? TSPSC. All right, notice is after 3 weeks for count.
Item number 7, Safiullah, Chief of Medical Health.
May I please, my lord? May I please, my lord?
Yes.
My lord, the present writ petition is filed, my lord, agreed by the action of respondent number 3, my lord, in not disposing of my representation, my lord. Seeking, my lord, some breathing time, my lord, to be transferred to my parent cadre. My lord, they have issued my lord, repatriation orders, HIGHCOURT authorities, my lord, abruptly, my lord, without giving me any opportunity. My lord, I'm ready to go to my parent cadre, my lord. I'm only requesting some breathing time in order to, my lord, fulfill the academic years of my children, my lord, who are studying in engineering, and my lord, they are pursuing the 12th standard. My lord, therefore, my lord, I'm requesting, my lord,
Repatriation order is dated 18/10/23. Where
Yes,
is
my
it?
lord.
You have been repatriated to which department?
Parent cadre, my lord.
Parent cadre is which department? Public health.
My lord, the public health and welfare department.
So that also is in Hyderabad only.
No, it's 200 kilometers. It's 200 kilometers away. It's 200 kilometers away, not in Hyderabad. I'm requesting, my lord, let them consider my representation, my lord, and my lord,
Appearance
give me some brief.
Hmm. There is a standing council. Have you served the papers on TSHC standing council?
Yes, my lord, I've done that.
On whom did you serve?
Standing council, my lord. THMC.
There are so many standing councils for THMC. On which council did you serve the papers?
My lord, my clerk has served the papers, but I'm not aware of the name. Let's have it tomorrow.
Tanban Road. Mr. Chandrasekhar Rao. And the name of Mr. Chandrasekhar Rao and this tomorrow.
Consumer extension for lunch motion will current Lingara today. Tomorrow.
What since may have this matter, my lord?
What are they going to do? What is the interim order? So what is the interim order granted for? So one day nothing is going to happen. Tomorrow. List it for explanation.
I don't know, hey, Gopal, chief commented
Yes.
The second respond has issued a notification, case 15, but calling for applications for appointment to various posts, but including the post of early interventionist cum special educator.
What is the selection process?
Selection process is case 15 mechanic. Case 15, selection procedure is also mentioned. But selection will be done as but as per merit, selection procedure is prescribed. As per merit of aggregate marks obtained in the concerned state education qualification, 100% only for marks awarded. But in
so there is no examination or anything?
No, nothing. Only merit is the base. But I made a representative application for recruitment of this post. But case 21 make identity, but ICT secured, the education secured 68.3%.
How many posts are there?
Only one post, but 68.3. But thereafter they issued a provisional select list that is at page. But page 41. But they roundly mentioned as 64.8 in page, serial number 5 is mentioned. My name is mentioned, page 41. Serial number 5 is the petition. But they roundly mentioned as 64.89 instead of 68.3.
Even if you are considered a 68, you are not coming with only one post is there.
Yes, one post. The first person, this first person has already joined in another post. And then I will be a second, immediately after the first person. But then I made a representation also, Millard, that 1/5/2023, page 44. This is my merit is not wrongly mentioned. Please correct it and thereafter they did not pass any orders. And then now they are going to appoint the meritorious person.
The presentation made around 1st May 2023. One will find whether the process has been completed or not.
1/5/2020, page 44.
Same thing he is also saying, yes. No, you have, there is a stamp is of 3rd May. So if you have not completed the process.
On the basis of
representation, if you have not completed the process, then you first consider the representation, thereafter do the process. Because obviously he has secured more marks than the second candidate, as per the list.
In page 43,
by tomorrow get instructions.
but page Just now our CC papers. Case 43 is very clear. That is Usman University control of examination. Case 43. As also issued secured 68 points.
So no, see, once he has made a representation, you ought to have considered it. If he has secured more marks, then you cannot, obviously whatever you have written here, the charge. There they have committed a mistake in, it is 68.43. It is, you have mentioned it was 64.89. What is the basis for that?
On Friday,
On the day after tomorrow, Thursday. Okay, let him get instructions. And the request of the learned GPM services to get instructions in the matter which day after tomorrow in the motion list. And the status quo as on today shall be maintained. With respect to the sectors.
Item number 9, Om Kakum, Chief of the Services.
The repetition file for consideration of the representation is in March. In fact, the facts of the case are petitioner's father worked in the respondent department for 27 years. He has died in the year 2010 year also. In fact, what I can't up to page 17 year also. After he has given a representation, then they verified his documents.
When did your father die?
2010 year also.
10 to 2010. What is their age now?
Now 44 years old.
But when did you make the representation of a
In
compassionate
fact,
appointment?
earlier representation I made, then what has happened is, Lordship, and I kindly come to page 17 here. Earlier, this
Yes.
is permitted to review.
Yes, yes.
Kind attention is invited in reference cited wherein the Deputy Director Social Welfare Karimnagar has requested to inquire whether certificate issued to R. Veeration, a resident of so-and-so village and Mandala Union or not. In this connection, I have personally verified the certificate issued to the KV Veeration and found the certificate issued to R. Veeration are genuine and correct. And local inquiry is found that Rahula Veeration is the only son and family member of Rahula Bakkaya, son of so-and-so. Therefore, I submit the certificate issued to Rahula Veeration in which his father's name is entered as Rahula Bakkaya is genuine and correct. Lordship, now kindly come to page 16 here. I'm required to read.
Yes.
I am to submit that Sri R. Bakkaya, son of Sayu.
All those things you can omit. You come to the relevant portion.
Yes, sir. Lordship, I now kindly come to last paragraph. Therefore, I request the Commissioner of SWAP.
Kindly issue
permission for appointment of R. Veeration, son of Bakkaya, ex daily wages, working for appointment on compassionate ground one, and as class 4 employee in any one of the existing items.
Okay. So
So
there was
nothing happened, Your Lordship. In fact,
that was
then
in
he has,
2011.
yes, Your Lordship.
Then what did you do all this time?
In fact, nothing happened because he is doing all petty works. Then he gave, when it has come in the paper, then he has given. Watchman of Petty come to page 14 here, the representation.
Page 14.
I Veeration most strongly submitted due to respect on seeing the news published in Andhra Jyoti News, dated so and so under the caption of Karunyan Ipunya Pakapu Darkshudru Vivaralu Pampandi pending. I felt happy and so and so. Then he gave a representation to her. Then he has given the copy to the second and third respondents. In fact, now only I am seeking is whether either they will say yes or no, because at least he will do some, because now.
Yes, who is appealing for the
response to the case here also.
You yourself have come, there is a recommendation. Thereafter, why did you not do it? 2011, get instructions. He has not, maybe, but what about you? He is not vigilant about his rights. What about you? Are you vigilant about your duties? Once a recommendation has been made, why a letter has not? See, if there is something from his side, some requirement from his side that he has to submit, I can understand he has never come forward, you have not done it. But here he has submitted all the documents, you have verified. The duty is cast upon you to give the appointment.
In fact, now.
That should be immediate.
So immediately you have recommended also. Why you have not given? What is the reason for not giving? So every day he has to come and visit your office. Your officer's office to see that he gets an appointment order. Once a recommendation is made, then you have to follow it up. Why should he follow it up? Why can't you do it? Get instructions as to why you are
I
not.
only request is your lordship. In fact, let there be some closure of this case. What I am seeking is only consideration of it. Let them say yes or no within some period. At least if they say yes, I'll get appointment. If they say no, then I will go to some other, because he will look for employment somewhere. Let them say, what I am seeking is only consideration of representation within some time frame. Let them say yes or no for that.
Get instructions next week.
In the actual motion.
Leonard GP for services 5. Whatever I have said, she heard it. She has repeated it.
No.
You want again me to repeat? Sorry, golden words are not repeated.
Item number 10, PV Krishna, HIGCOURT services.
No. You're challenging the departmental proceedings. Charge memo is issued. Oh, what about the criminal case? When was that registered? 17/12/21. So to the charge memo, did you submit your explanation? So what is the stage of your departmental proceedings now? Appointed. All right, then similar order. Have you found a copy of the similar order that I have passed? All right, no problem. In this case, contempt also is pending.
Review of suspension. Second case is review of suspension.
But here, disciplinary proceedings and criminal proceedings are going on parallelly. So I have been granting stay of all departmental proceedings till the conclusion of criminal proceedings.
Actually, it's not yet fine.
Not yet fine.
What are the charges? And regarding the evidence that get used. My submission to the respondent number 5 is state, like, until I'm actually defined the criminal. Now, you know, that they're capital by saying that not case take above the delay. So that should not immediately say that how the same set of questions or the charges actually. Once the charge sheet is, they come up with the form. Your statements made in the charges in the case and then all is submission.
All right, pass over.
I know, PV Krishna, HIGCOURT.
Hmm? 18. 18. What is the order?
Getting the orders.
If they are already working as BRS, let them continue to work with BRS. And all right, similar order as in page number 80. It's after 4 weeks.
Yes.
Yes.
petitioners are asking in the denied promotion, the count of pendency of charge sheet. In the first case, allegations of 2013.
Criminal cases are only of 2022.
2013 is the crime. 2013, 2021 signed, 22 CC. Next case now 2015 crime, 19 is CC. 2019. In similar circumstances, the officer please to pass an order, page 53. Two orders the officer passed, page 53 one order.
Yes. Subject to the result of the case.
Yes.
Yes.
To fail your watches, unloading of your password and equals page 36. This is one case, the report of CC. Other case, it was report of CC as well as 36 to 39. I filed both the orders. Page 41 is property.
So without reference to CC, and this is
the first one is without a CC, page 53. The other one is page 36 to 39.
that also is without reference to CC only.
And in terms of without a CC, in terms of but also in terms of
Yes.
Rejection orders after the company's mind. Presentation, page 22. First paragraph, last question is there asking the that they have asked. They made one more representation that also enforced. The watchman kindly see that.
Where is the second presentation?
23 is one more representation. Page 23, page 27 and 23. Because all their advice initially, further we submit that we came to that recently some of the options got coming to so and who was facing ACB case pending instead. So they requested for promotion. Earlier they asked for this. The juniors are promoted, not admitted. Those are facing case for also promotion. And then put the case for subject also the single case.
On the similar order as in page number. Four weeks.
Item number 14, Sriram Polal, Chief of Services.
Yes.
This was a village revenue. They were going to pay back in 2006 to 10. They were sought to be removed in 2011. Actually, now what is under challenge is a termination order, which was the decision was taken way back in 2018. At pursuant to this, they have been terminated. A similar, the exact same order of termination is at page 58, passed by the collector.
Why were they terminated?
They were terminated for the reason given there in 2010 when all of this started was apparently their appointments were irregular in as much as after 2002 there was some ban on new appointments apparently. That is the reason given then. So the CCLA had then asked the collector to stop proceeding with any terminations in 2011. There was a categorical memo of the CCLA. Despite that, an action was being taken. The petitioners filed OAS before the administrative tribunal. Administrative tribunal asked them as an interim of measure, directed them to be continued. This is just a broad outline, instead of taking your lots of the paper, to be continued. In the final order, based on a letter given by the collector himself, saying that these individuals were working regularly, when that was presented to the court, the interim order was made absolute as a final order, saying that they ought to be continued.
challenging that the state filed a writ petition before this honorable court. Interim suspension was granted way back in 2014. That while that issue was pending, in 2018, the collector takes a decision. He refers to all of this. He refers to the fact that the matter is pending and there's an interim suspension. Prior to that, I was protected by the orders of the administrative tribunal. He takes a specious plea that all the people, vacancies which arose because of these individuals, they have already been directly recruited in 2012. Therefore, there is no need to continue them. And he says, they must be terminated and finally see the last.
So you're not challenging the termination order of 2018?
I'm challenging that.
Okay, notice.
So this is the matter.
We have 4 weeks to come. Yes.
Number 15, P. Ramana, GP Pasao is.
Plus the and the same. Of the judgment filed in item number 17, both may be changed. The petitioner is due to retire shortly. Petitioner is due to retire shortly, is working as Municipal Commissioner grade 1. For 2005 and 7 allegations, they issued a charge memo on 25/1/2008.
2000?
Allegations of 2005 to 7.
5 to 7.
7. Charge memo was issued on 25/1/2008. Immediately, Millard, after furnishing a report, record note, I submitted my reply. Thereafter, the inquiry officer submitted report on 17/8/2010. 3 dates are given. 17/8/2010, inquiry officer submitted report. Inquiry officer himself stated an inquiry was conducted based on the written arguments. This is very important. Inquiry was conducted based on the written arguments of presenting officer and the charged officer. Because presenting officer not chosen to examine any witnesses. Therefore, it is only based on written arguments of both parties. Inquiry was conducted. This is the first time we are hearing. But this report was prepared on 17/8/2010.
Just a second.
But after 4 years after some.
1 minute, just a second. In the Vinnamo, you have to put there. Yes. Yes, sir. So
Report
2000.
of inquiry officer dated 17/8/2010.
Now what happened?
So that's one. This was communicated to me after 12 years, that is on 16/2/2022.
2010 inquiry report has been
Communicated on
22.
16/2/2022 with show cause notice, proposing punishment of stoppage of 4 annual grade increments. I submitted reply. Thereafter, they imposed a punishment of reducing the pay of 4 stages below. Effect on is future increment and effect on pension, which is not proposed even in the show cause notice. Inquiry report proceeded only based on written arguments of presenting officer and reply filed by the charged officer. There is no inquiry at all by examining the witnesses or marking the documents. To establish that, so please just.
So you're challenging that punishment order.
Punishment order, reducing 4 stages in the time scale, which will have effect on pension, which will have effect on future increments. Such type of punishment is not provided under the CCR rules at all.
So the orders are dated 18/8/23.
Yes, ma'am. This is
the order of punishment.
Yes, ma'am. I have challenged this order on 4 legal grounds. One is that there is no inquiry under Rule 20. This is a major punishment. It affects 3 ways when it affects the career of the petitioner.
Where is that inquiry report?
The inquiry report, it starts page 50, the answers directly come.
Page 50.
50. Page 50, para 2. Subsequently, on perusal of the connected record.
Page 50 starts with, I have taken the second repetition first.
First only alone.
849. Yes.
Page 50. Second one.
Yes.
Subsequently, on revision of the connected records and material process, this case was posted on hearing on 23/6/2000 and recorded the plea of charge office up to 9 of 6 in which all CEOs narrate the charges framed against them. As no witnesses were enlisted in the charge memo of CEOs, presenting officer also did not propose any witnesses to be examined with the question. The latter of the CEOs were examined under rules, which none of the CEOs were proposed any witnesses to be examined on their behalf. The presenting officer was requested to file the written arguments in respect of the charges framed against the CEOs. Subsequently, presenting officer filed written arguments in respect of charges framed against the CEOs before the inquiry authority on 17/12/2009. A copy of the same was given to each of the officer, requesting them to file written arguments. If any internal CEOs had filed written arguments before forum, case is therefore taken up for writing a report. This is important. The case is therefore taken up for writing a report of inquiry which is as under. Page 57 was just one.
So did you take this objection when you submitted your explanation of the show cause notice?
When they proposed a punishment, I raised this objection.
Where is that?
Before that, 1 second, I read.
I have seen it. The report of the inquiry consists of 4 parts. Case of department is proceeding, charge officers, assessment, finding. Obviously, they have not conducted any. That's what you want to say, or what is it? Sorry.
But even as per presenting officer report, written arguments, he has categorically stated charges are not loaded against me. So that is 1 second. Page 61, the lordship of the same report of inquiry. Page 61.
Yes.
The finding of page 61, written arguments of presenting officer in respect of charge and CO1 minute. Then you also stand it down to page 62 bottom, the observation of the presenting officer in written arguments. This is the written arguments against me by the presenting officer.
So this is with regard to CO2.
CO2 is another officer and CO1. The finding given is that ultimately,
since the
situation of historical outreach made by CO2 cannot be proved, the question of role of CO1 cannot be concluded. Therefore, explanation of CO deserves to be considered. This is the written arguments of PO. There is no other evidence except the written argument. Now, at page 69 is the finding given. Page 70 last for finding here. Page 70 last. In respect of CO1, Rajendra Kumar, charges 1 to 4 are held proved to the extent of weak supervision over financial matters in the municipality and also weak supervision over the staff. When the presenting officer himself says that my charge cannot be loaded against me, the finding that I am responsible for weak supervision, there is no evidence at all gathered during the course of inquiry. But it should be proved either by moral evidence or it should be proved by marking the document. But the basis for charge is the report of RDM. That report, when the other of the report was not examined, there is no marking of documents. Then they enclosed this copy of this inquiry officer report and issued a memo at page 48. That is 30 years back. Page 48, for second para I will read it. This is the date of the Lord's can you see 10/9/2010. Third para I am reading. The government of the careful examination of the inquiry report agrees with the findings of inquiry authority made in this report. Therefore, a copy of the inquiry officer report is hereby permission to the primary officers mentioned the opportunity to make their written submission. My humble submission here is, but after agreeing to the report, what is the necessity of submitting objections to the report? This is contrary to constitutional judgment.
All right, this was communicated to you when?
This is communicated on the same in the year 2010 itself. No, I raised my
But-
objections.
But you said the inquiry report was not given to you.
Was given to me
Till,
after 2010 itself.
Okay.
I submitted my
But the
objection.
show cause notice for punishment was given in 2020.
No, my objections to the report at page 71.
Hmm.
Lordship's got it.
Yes.
Page 71 dated 16/12/2010 with the acknowledgement.
Hmm.
Then my lord, page 73 is the next document, my lord, after the fact, 12 years.
Okay. Yes, madam. There is a punishment order dated 18/8, 17/8.
Lord, punishment order at page 83. my lord.
Hmm.
Sorry, my lord, 81.
Yes. Notice of admission. The that's GP for services 3.
And number 16, Bhaskar Rao, GP for services.
Yes, it is the third respondent of the Telangana Municipal Council. My lord, the second respondent has issued a notification filling of the vacancy, which is the page number 15.
You are challenging the appointment. To
Appointment
the
order.
fifth
Julian was
respondent.
candidated. My lord, the page number
What is the
15.
date of the appointment order?
Date of the appointment order is 29/9/2023. My lord, the 19 May to March 25th of page number 18 May. 18 is the provisional list prepared by the third respondent.
No, notice has to go anyway. Notice for admission. The Leonard Council, the Leonard GP for services, which services is taking? This is dated March, no, September. He might have taken charge.
No, he has not taken charge. He has not taken charge. And he is the junior most candidate. But only not to fill up the post.
The Leonard Council for the Commissioner submitted that the respondent number 5 has not yet taken charge of the promoted. If that were
And number 18, Rajesh Rao, GP for municipal.
so rejecting the claim. What ground has it been rejected? Hmm. Married daughter. She's the only daughter. Siblings are there. And Hmm.
But they only entitled, they made a representation. They only made a representation of nobody's the made nomination. They didn't take it.
Is the only one. This is, when did the son die? Father.
2016,
Father or mother, who was the employee? Mother was the employee.
2016, within the time they submitted application to the rejected law.
Petitioner's mother or she updated. Petitioner's mother, she updated divorce service.
Even divorce of married also entitlement.
Siblings are there, I'm appearing for the student 2 and 4. To get the instructions for okay, because it's a case of rejection only on the ground that she is a married daughter. At the time of death of the deceased employee, subsequent to the death of the applicant filed divorce petition. The family court after the death of the deceased employee on 1/10/2016. So how does that disentitle the petitioner? Married son is not a married son is eligible. Married son is eligible, no? So why not married daughter? Eligible. Yes. That you can consider. You haven't considered her financial distress or anything. What you have said is she is a married daughter, so not eligible. That's it.
Remember that also there's requirement in the MRO given the
Is there any, you haven't said that there is a private claim?
No, there is no.
But in service and applicant's daughter is completely dependent on mother. The applicant filed the divorce petition after the. That has got, what has got that to do with this? What has that got? Even if she is not, she hasn't obtained divorce, she is a married daughter. If she is dependent on the mother, she has no other source of income. You can consider. You haven't taken all that into consideration. You haven't taken that into consideration at all. Only because she is a married daughter, yes, immediately threshold itself, you are. Yes. Part 2 to R4 name is appearing. Name is as per my instructions, the standing person has stated that she is not attended because they have some other instructions also. Where are those instructions? I'll pass it over. Ask him to come with the instructions. From the department, all right, tomorrow in the motion list.
And number 19, Dingarao, keep for services.
Why it was for listed, directed to be listed in motion list?
That's
It's next week, they, Delhi. Or hearing.
Yes.
It's in another name. Print the name of Mr. Take this tomorrow, in the motion list.
Item number 20, Prithviraj, Chief of Education.
Allotment and 317. Yes. Okay, where is the representation?
Page number 15.
15. This is dated 27/9/22. Okay, immediately the next day on page. Yes, same copy service 317. The petitioner has made is seeking a direction to dispose.
application refusing my request by the university to grant extraordinary leave permission to contest in an election, general election as an independent candidate. I am professor of the law college. Earlier, my lab is on good court merit laws. Earlier, the university also permitted various other professors in lab.
There is a case of rejection.
My lab, page number 14 is the order. Page number 14. With reference to your letter cited, the request to permit contest in the assembly elections for the year was placed before the executive council and so on 20th October 2010. The executive council is resolved as an
Who is appearing for the university? Yes. Yes. Yes.
No, university employees while being on duty take active part in politics, holding office, electing, otherwise in any political party, standing for election to state legislature or parliament, take part in any other elections, provided that the university take contest election from the graduates or teachers' scholarships. By taking leave on loss of the entire period of his work and also he is elected for the entire period which he is elected. So basically, the deputy is not entitled to contest for the legislative parliament. He can contest only for the legislative MLC.
Teachers
council. This is in tax. And I said, good to know he is and then the first paragraph of your question on any party ticket. I am not seeking for any party ticket. Independently, I am contesting the general elections. So, not to be candidacy. No university employee shall, while being on duty, take active part in politics, which includes holding office, elective or otherwise in any political party, standing for election.
So, holding office elective itself is as an independent also. Not only political. Political comes later.
That is my continuation. Not parliament to take part in any other election on a party ticket. Not subject to. If I contest on behalf of any political party, on a ticket, I can return from contesting the elections. But I am independently participating. You want to make any
is there any
19 University Grants Commission also permitted such teachers and professors to contest in the elections. Not to page number 19. The program of action on national policy on education under para 7 4 class 1 so. Teachers who are elected or nominated to parliament or state legislature will be required to take leave of absence during their term as member. However, in this process, they will not be losing their seniority or increments. The purport of the circular issued by the UGC is also valid. A teacher can be permitted to contest in an election, whether legislative or parliament. Contrary to that mallet, under Rule 6 mallet, by interpreting it as a mallet, since he is holding a office, he cannot be returned from contesting an election. When an issue came up mallet, in earlier some of the professors mallet were permitted to, not my candidates page number 21. Earlier one, Dr. Vinod Kumar was permitted to contest in election.
That's also executive council.
Council subject to some mallet, and later mallet after permitting him in the year 2014, later during the year for conducting in the by-elections in 2015, his permission was rejected. Challenging the same, he filed a writ application before this honorable court. Not my see page number 25 is the order. Where an interim order was passed by this honorable court. Page number 25. Petitioner is the serving officer in the Usmania University. He intended to conduct.
Then the facts are slightly different. There initially they gave permission, subsequently the by-election they rejected. The earlier permission given was not withdrawn, therefore.
Ultimately, this honorable court has directed the authorities not to take course. The purpose of the order is to permitting him to contest in the elections. UGC regulations even the circular was issued also permitting the teachers to contest in the elections either in the legislature or the parliament.
As an independent candidate.
As an independent. I am not seeking any party ticket. In fact, my father was a MLA for
continuous 5 terms married. And
Inherit that,
less married. That's why married, consulting married, various married, different communities of people approaching me to contest in the elections. Consulting my wisdom to the welfare of the society.
The result they are not interested.
Your rules provide for it. So you have given permission to others, why not to the? So if you do it for one, you have to do it for others.
Yes, married. That's what
Whatever, see, that is his choice, whether he wants to continue, he wants to contest, withdraw. But initially, before even filing a nomination, you have to give a permission. So your rules permit people to contest elections. And you have done it in other cases, then why not this first?
Yeah, now after EC approval only they are the implementation.
In that case also, you have given permission, EC has given permission, and subsequently in the by-elections. And that was challenged before this court. Court has allowed it. So why should her case not be considered? And this was page 1123 was the order.
The conduct married, the respondent married. The alleged meeting was held on 20 October 2023. That was communicated to married on Friday evening. Which clearly shows married intention of the respondent to refrain from contesting the election.
This will be, what is the last date for filing of nominations? 15th, huh?
10th married, 10th is the last date.
10th is the last. Today is 7th. What other instructions will you get from other than what they have said? All right, tomorrow in the motion is. Tomorrow, no? No, Friday is the last date. He has to file a nomination. So tomorrow, by tomorrow you get same.
Since married rule is also in my favor, married cannot challenge it. Married. It's a year married. Rule is also on any party ticket.
All right, tomorrow we'll take an issue.
I remember 22-23, AVS Lakshmi, GP for higher education.
What is the case?
See, the recovery of university teachers, retirement benefits, they recovered amounts. If a lordship's order may not have filed at page 28, 38.
You're asking for refund
Refund.
of the recovered amount.
And that 38 proceedings are of 2012 year. Now the proceedings will have present proceedings are subsequent proceedings from 2017 proceedings.
This is Rafiq Rasid. Yes.
No, those cases. No, page 38. Not you take page 38. Page 38, proceedings of 2012. And it was filed in 2023. And your lordship allowed it by directing the refund. The refund was ordered at page 38.
38 in which position?
Page 38 in 26796.
Even now.
27696.
To refund the reader increment? Reader increment.
Same case, 38. 2012 proceedings. And
covered matter, why again?
Very covered. And your lordships also have seen, my lord. Your lordships have seen the judgment of the Supreme Court, my lord, date your lordships have seen. The judgment of the Supreme Court have filed, my lord, at page 25. Judgment was of 2014. After 2014, they should not have recovered.
The same matter. Huh? All there. Some similar order as in page number, the order in WP 131. So both cases is order.
Number 24, Venkataraman, Chief of Agriculture. And we permitted to withdraw.
What to withdraw?
The person, in this case, with regarding to the years, since the years is pending, the Congress party nominated to meet the party.
You don't want to. So you don't want to withdraw now.
Yesterday, this development has happened.
So better withdraw your PRS application, otherwise they'll allow it now.
That is pending, that those two petitions are pending.
No, once, unless until your, VRS application is withdrawn by you, if they accept it, then you lose both. This and that. Anyway, you want to withdraw the application now. At the request of the General Counsel for the petitioner, the petition is dismissed as withdrawn.
Item number 25, Satyanarayana Murthy, Chief of Services.
Is the matter proceeding punishment page number 14, recording of two annotated including cumulative effect. Committee letter
31/1/2020.
22.
Notice just after 4 weeks for counting.
Item number 26, Avinash Shetty, Dr. Praveen Kumar.
Yes.
The institution is working as a associate professor in the Hyderabad campus. Where he was undertaking one project on behalf of the Pilani Government of India. The Government of India have initiated some proceedings and ultimately issued page 116. An office order dated 17th January 2020. Stating that he is blacklisted. Page 1.
Yes.
The principal investigator for ISRO, on the ground of concealing of facts pertaining to this project, is hereby blacklisted and is also barred from consideration of any of his projects for 10 years by the Department of Biotech, by the Government of India. Then Pilani answers the letter at page 117 in September 2021, stating that as per the order so and so is charged with not providing certain communications related to the project and thus impose a stricture for the next 10 years. However, the exact reason for the said decision is not clear to the issue. In this regard, I would like to ensure that during the course of investigation by DBT, as per the statement of PI, has duly responded and provided the necessary documents as desired by the DBT authority in a timely manner. The institute coordinates the sponsored projects through a dedicated office of sponsored research and consultancy division. Professor so-and-so has been informed that he would submit an appeal to the office of the secretary for the reconsideration within 3 months of the order, and that he has done so, and also followed up with a request to your office to grant him an appointment for him to meet in person, but there has been no response despite his several demands. In this matter, I would like to request you to provide us with the exact reason for such steps and seek your guidance and help to understand the problem. Knowing the fact will immensely help take necessary measures for end so that this does not impact the institute. Then another letter was addressed at page 118. At 119.
Yes.
Is also by the Pilani. It appears that the principles of natural justice have not quite been followed in this case, and the decision on this appeal is still pending. In addition, we have no specific information which indicates any wrongdoing on part of solution. So, the Pilani is very clear that I have not committed any irregularity. And in fact, the allegation is that I have not furnished the information. In fact, I have furnished the information, may I draw your lordship attention to.
So
Page
ultimately,
110.
what happened now?
Now what happened is, Bits Pilani now issued the proceedings at page 133. Because Bits Pilani was clear that I have not completed any irregularity. But now, to consider my candidature for promotion, they withhold it on the ground that I have to await for the outcome of the inquiry. The faculty promotion committee assesses the suitability of all eligible faculty for promotion. Note regarding the recommendation of the committee.
It's only kept in abeyance.
Yes, ma'am.
There is no.
Since no communication regarding the outcome of the inquiry is being conducted by the DPP has been received by the institute till date, your promotion has been held in abeyance till the finalization of the inquiry by the DPP. But the inquiry by the DPP, even as per the Bits Pilani, is not proceeding. But I prefer an appeal that as on page 120 you are saying. 5th March 2021.
What is the order of the DBT that
DBT
blacklisting?
116. Blacklisting me. For the work awarded to the Bits Pilani. That means the work awarded to the Bits Pilani is at page 74. It is not allotted to me.
You are appearing to the central government. Notice will have to go to Bits Pilani. Private organization.
Bits Pilani now, they are only on the ground that this blacklisted.
So that is the order that you are challenging. Not only the.
I am also challenging
the blacklisting.
On page 116.
Both. I'm seeing that.
The
So
reason
notice.
again, you blacklist page 116. No opportunity is given to me before blacklisting me. But blacklisting a professor who undertook the project on behalf of the Bits Pilani. There is no rationale given. And Bits Pilani requested, please give me the information. What the allegation, if you respect for a moment, is the allegation is that I have not misappropriated. Allegation page 116 for a moment.
Yes.
There are 2 minutes. The DA has not shared the correspondence made by him to this department pertaining to this project, which amounts concealing the facts required to be taken on record by this department to investigate the matter. These facts and records are treated as essential documents to investigate the matter and the role of the PI. They don't have any. Now I may just draw your attention to my letter at page 110. But I have furnished the information. 112 also I have furnished the information. One 13 also I have included all the attachments. So the communication which they want to investigate is a different issue. Even Bits Pilani has communicated the information that I.
No, let's issue notice.
Short notice.
Short notice. Notice
Because the government of India should answer why they are.
Notice this for admission. The deputy solicitor says.
Number 27, Ravi Kumar Reddy, thanks Ravi Kumar.
Huh? You want time? You are for the petitioner. Next week.
And number 28, Venkateshwara, Chief of Services.
Management. In all driving license, and also in service department. Issued as 1954, 1960, but that was altered recently, 10/7/1963. petitioner retired from first part, notice.
He has already retired.
Recently, just last week.
Okay. Notice for admission. Mr. Tum Srinivas takes notice on behalf of the respondents and seeks time to file counter. Just after 2 weeks.
41 also similar, maybe that's also my pending. 41.
31 or 41?
41.
31. Both. Same. Yes.
29, Rajesh.
Hmm? What was the time granted?
7 days.
And how much time did you take? When did you make the representation?
11/8/2023.
So when will
Restatement order 20/20/2023.
Huh?
20 March 2023.
Okay.
11 days.
So what is the ill health that you are saying? You say you have suffered from some ill health.
Leg fracture.
Leg fracture. Where is that? That you haven't said anything. Only lately my health condition deteriorated, as such I could not report. I recovered from ill health and later became fit and approached the authorities. You haven't mentioned anything about the leg fracture. None. You haven't said high BP also. Nothing. So you want your representations to be considered? Yes. Yes. The Learned Counsel for the petitioner submitted that the petitioner was working as a
Services.
what about Zoom Srinivas 30?
Continue, into the same.
Venkateshwara Gadi 28,
28 and
31.
31.
31.
Oh, sorry.
30 only.
Number 30, Tum Srinivas.
What is the order in EP?
The respondent is appointed as driver because he got suspended on 11/3/2013 on the ground of he got community obstacle. likely not for order of the district, challenging the same not the corporation, but appeal is honorable court may not granted not stay with regard to the extent of pathway. During the pendency of the writ appeal, we have paid the other payment. But subsequently, the writ appeal for issuance we got on 28/3/2020. But now the EP was pressed for regard to the pathway. But the petitioner has made the page number 22 of the order. These are the pathways which is entitled as per on claiming. My respectful submission will also kindly.
There is 1,14,000, 11,43,580.
Yes, my submission is that from March 2013, this is the period where was suspended and removed in the month of September 2013. Now, during this period, we paid subsistence. But he is not entitled for full back. That is my respectful submission with regard. The other issue is whether the petitioner is entitled for regular leave, which he is out of service. Not I extracted the rule position. Page number.
So how much would that come to? Subsistence allowance and
the same page. You also can see page number 23. Coming 4,83,000. But this the rule 34 of the regulation.
See, he is entitled to back wages 11,43,000.
For that, I have committed to kindly.
Let's come to what is the amount that you want stay off. Only earn leave, okay, that can be considered. Gratuity you have to pay, PF you have to pay, back wages you have to pay.
Page 26 for it. These payments we have already made. Page 20. Amounting to 14,88,000. To be paid in the year 2017 and 18. And this is comes with regard to PF, gratuity, terminal leave encashment, CCS, SPT, SRPS, and this. After dismissal of the writ appeal also, again we have calculated, and we have arrived an amount of rupees 7,79,000.
No, 14 lakhs is, you haven't paid back wages at all. See, total is coming to 27 lakhs.
No, this was paid during the pendency of the writ appeal.
All right, now this is, see, 27 lakh 57,214 is the total amount to be paid.
As per the
that includes back wages of 11 lakhs. You have only paid 14 lakhs.
14 lakhs. Back wages were calculated after the dismissal of the writ appeal.
Okay.
That will come to 7,79,000 as per the.
According to you, it's only 7 lakhs.
Yes.
Not 11 lakhs.
Yes.
Okay.
Page 33, I mentioned the order also is extracted.
7,79,042.
Not ready to deposit this amount. The only amount coming different with regard to encashment of the terminal leave, as well as with regard to the back wages, with regard to the certificate.
No, out of total 27, 14 you have deposited.
88, it's almost 15.
15 you have deposited and 8 lakhs. It will come to 23. So 5 lakhs will be remaining. PF and gratuity. Gratuity itself is 9 lakhs. So 5 lakhs. Earned leave is 5 lakhs. Except the earned leave amount, you deposit the balance.
This is only the calculations of it. Not for the time being.
And what about the interest and all? No interest was granted.
Will be by the labor court not which again the
No, I'm asking you. I'm not going to impose the interest now. Has the labor court granted any interest? Notice before admission? 32, 33, same. It has to be listed along with the batch. Along with the So you want to get instructions in the matter, or what do you want? 33, yes, what do you want? How much time to get instructions? At the request of the Learned Council for the Planning Council to get instructions is after 2 weeks. Okay. Yes, larger motion.
Item number 34. Candidate Lokanal, Ravi Babu, Govindaraju, Subhan.
This matter has been referred to the local settlement and by orders dated 39/2023. The orders have been passed. The matter has been settled. In view of the same, the separation disposed of in terms of the local settlement.
Copy of your
Now let's see. This matter is already settled matter for the local adalat. It only has to be closed in terms of the local adalat award. Item number 35. Any award in the There's an award here. Presented over Justice Lakshmi Narayana Ali Shetty. That is the advocate. In the presence of Honorable Justice Lakshmi Narayana, there is already a settlement. Huh? No, this is Alladi Karthik. WP 13887 of 23. You have another file perhaps.
Item number 36. Yugandhar Reddy, GP for School Education.
no order.
No order. No. How much?
Next.
Next week. No, if there are, you want to get instructions or no orders have been passed. Instructions, then next week.
Item number 37. Amresh Anand Sanghi, GP for Services.
This outlet. Next week.
Item number 38. Amresh Anand Sanghi.
Same.
No, below 9.
In the
In the
rejected. So what do you want? Fresh representation? All right. Already rejected. Representation is rejected by orders dated 8. Close with liberty.
Item number 40. Rajesh, GP for Education.
Then similar order.
Item number 40. Gangaveli Gopalakrishna.
Close with liberty.
orders, no orders.
Gangavatu, first. 40 I said. Okay, 41. Next week? Next week.
Item number 42. Kiran Kumar, GP for Education.
Set similar order. Close with liberty.
Number 43. Srinivasa Madhyaraju, GP for School Education.
Same similar. Close with liberty.
Item number 44. Srinivasa Madhyaraju, GP for School Education.
Same similar order.
Allowed.
Allowed. The representations are allowed and the allowed rights under the no further orders. Close.
Item number 45. Gopal Rao, GP for Education.
Close with liberty.
Item number 46, Srinivasa Madhya, Chief of School Education.
Same.
Item 47, Sirisha, Chief of School Education.
All right, same. Close with liberty.
Item number 48, Prithviraj, Chief of Education.
1 of 2023 is filed.
Huh?
Amendment will face, sir.
No, IA3 is for amendment of the prayer. Huh? Huh. Designation of the petitioner. Instead of secondary gradation, it was printed as SG instead of SGT. And the new allotted local cadre Rangareddy instead of Vikarabad. Rangareddy instead of Navamela and also small. So you want to get instructions in that. Next week.
Item number 49, Srinivasa Madhya, Chief of School Education.
Consider no further orders required. Closed.
Item number 50, Srinivasa, Chief of Services.
Closed with liberty.
Item number 51, Rajesh, Chief of School Education.
Same. Closed with liberty.
Item number 53, Rajeshekar Reddy.
Section 7.
Not yet discussed. How much time to get instructions? 2 weeks.
Item number 54, Rajeshekar Reddy, Chief of Panchayat Raj.
2 weeks. Next week. Next week. 55, 2 weeks. Acha. 54, 2 weeks and 55 next week.
Item number 56, Srinivasa Madhya, Chief of School Education.
Yes, what is this for being mentioned? And then the column of the occupation is existing. Kota file is a headmaster and Rasar.
Retired in occupation, retired headmaster.
Retired and Rasar. Should be school assistant. Not retired school assistant. School assistant, no? Retired school assistant. What is the relief that you have sought? Huh?
The amount it was recovered.
Oh, that amount.
Annually.
Okay. It's allowed and the cost settle is allowed to be allowed.
Item number 57, Rajeshekar Reddy, Chief of Services.
The matters pertaining to the compassionate appointment, the last occasion I was argued that they was rejected on the ground of age criteria. I filed an IA, your lordship kindly taken up. The last occasion, I was not made enough. The representation before the government who is the competent authority to relax the rules. Then I also filed at present along with the IA. But the judgment of the Honorable Court Division and as well as the single bench.
You have not given the papers to.
Division bench judgment also covering the age relaxation and also by quoting certain GOs. But consider my application which is pending before the first respondent and along with this by following the judgment. And fourth I was sending, and sixth it was received.
Where is the
application?
Division bench judgment.
Division bench judgment coding in that single judge is followed by the division bench by regarding the statement in third paragraph.
So where is your representation? Page 15.
Yes. I mean, we wrote the report.
Yes.
The challenge, it's suggestion from the vendor, that's the data before the government. If the application may be for the government or.
The representation to be disclosed. This question.
Item number 59, P.V. Krishna, Jitendra, Dr. Praveen Kumar, Pankaj Reddy. Item number 60, Sai Prasad, Chief Pandit, Rahul Reddy.
All matters to be argued have to be passed over. All right, pass over.
Item number 61, Lakshmi, Jagannath Rao.
Yes, have you filed a counter? Yes. So where is the counsel?
That they will take time for 2 weeks.
Nobody is there. What is the issue here? What are the proceedings that are under challenge? Suspension order. Yes.
In this case, we made a lot of objection into.
Oh, they have filed a counter already.
In fact, and told the EC has again broken the suspension. Not communicated to us. We filed contempt also.
At the request of the learned counsel for the petitioner to file a rejoinder to the counsel filed by the respondents. After 2 weeks.
2 weeks, not interim order will wait.
In the meantime, interim order granted by the should stand extended.
Item number 64, 65, 66, Balkishan Rao, Chief of Services, Jivanda Reddy, Ram Gopal Rao.
Yes. No, I think there was.
Lordship can consider, I am appearing online, your Lordship can consider. Government yet to be filed a counter. Lordship directed the government leader to produce the persons who transferred from other district to Telangana district. I then today they have not communicated to the petitioners. List of the candidates.
No, there is no urgency in the matter, perhaps. Contribution. So nobody is there. Delegates also are there.
Implead application is not at order because they are not focused and I filed a counter under the implead application.
So implead applications can be allowed there.
I filed a counter stating that they are not entitled to be included in the
No representation, we have the respondents, unofficial respondents, unofficial respondents. List after 3 weeks. Interim order granted earlier should stand extended in the.
You also find
You cannot interrupt like this. I'll consider your request at 1:30. If you mention. Yes.
67, Vikram Kumar Reddy, GP for Services.
May it please your lordship, beg to present this case on a virtual mode, my lord. My
Yes.
lord, questioning the suspension orders, my lord, the petitioner before your lordship is the deputy Tahsildar, my lord, he was suspended. So questioning that this writ
Order
petition
is
was
filed.
questioning the suspension orders, my lord, on physical verification of the stocks, my
Already
lord.
there is an interim order in your case.
Yes, interim order is with respect to the demand notice which has been issued, my lord, that is at page number 20.
Yes, yes. You want time to counter. At the request of the resident seeking for services. To file
My lord, there
counter. It's after how much time?
My lord, there is an implied petition which has been filed, my lord.
There's an interim petition.
Implied petition, IA number 3.
You have filed. You want to
Yes.
implement?
Implied MRO of Medak, my lord, and RDO.
Any objection to the implementation? petition? Implementation petition IA3 is unopposed. Accordingly, the register is directed to amend the cost rate and issue notices to the implemented respondent 7 and 8. Yeah, who is taking notice? You will take notice. Okay. Just after 4 weeks.
May I make a small submission, my lord?
Yes.
May I make a small submission, my lord?
Yes.
My lord, yesterday there was a second demand notice which has been issued, my lord. As I could not submit the order copy in the stipulated time due to the vacation, my lord, they have issued a second notice, my lord. That may be observed if our lordship so pleases. The demand notice with respect to whatever the second notice which has been issued.
Second notice is for the very same demand which has been
Yes, my lord, very same demand, my lord. Very same demand.
Stayed by this court. There is a interim stay of demand. Now that the interim order is being extended, you can communicate it to them.
Obliged, my lord. Obliged, my lord. Obliged.
Yes.
And number 68, Praveen Kumar, Radhakrishna.
Both are same?
Both are the same. One order is there. You find order and Guna petition.
Who is appearing to the respondents? You are appearing.
He is the latest in the respondents in the suit for file.
You are the plaintiff. You are the defendant. Defendant. Okay.
The super dismissed for default. They find the application of social of the scrutiny. And in that, you know, both IS that find on the other section 5 petition. One is another rule, 9 another is section 5
limitation. How much is the delay?
They are the only issue is not around the study section. Now they say the notices were not served. Because respondent number 1 says
So IA 379 is for recall. Recall has been recalled. On the ground that service summons were not served to the plaintiff.
My continuous service is there. Now in the order was taken, the notices are served.
Where is the order?
That is including order is not TSHC. Common order. The last second when the matter hearing. So that your counsel is also present in order to secretary presence of counsel, page 7. So the counsel is Satyanar enough to meet with that. His presence is not there, how can you raise the question of non-submission, non-submission? And you ought to do with the rule. It must be other thing, rule 4 class 2. Which especially argument that we don't know because they live different addresses. And whether is I'm saying that there's some notices are extra on the door of the some of the respondents.
Service of summons on the respondents.
Yes. We are the
You are the
respondents.
respondents. So a producer of the record received from Municipal Court shows that OS number 7 was filed for the for partition separate. The issues were settled and later the matter was posted for trial. The government posted the suit was dismissed for default. Petitions as referred by petitioner of the commission parties. Seems to be reasonable to review the nation with more opportunity can be given. They were said ex parte with regard to this IA.
Establishment without notice was issue ought not have been allowed. That is my case. Now, once now last occasion, the order was passed. Someone in the road.
Oh, this is the case. What's in the record? I'm sorry, I think we got confused about the date of receipt of the record. It was sent yesterday, I think. It was not received yesterday. So we'll
post it today.
I'll post it after a week. It has to come from there. Next week.
My submission. After 2 weeks, post it.
Interim order is
You got it, next
the
week.
interim order is to be extended.
They say that will not be extended for 2 weeks. Post on next week.
The record of the lower court is yet to be received. Before list next week.
Yes,
Till the orders in the petition are filed, are disposed of. Till the CRPs are disposed of. And then further orders. So once that is, it has already been dispatched from there, it will be received here. So next week we'll take it. Interim order is until further orders. Next week.
I mean, until further, due to any reason and all, it is not again seen, then again it will not see the daylight and all. That's the reason, as my letter friend said, that's the reason I have not opposed. Let it be for 2 weeks. Let it be, I mean, the CRP may post it next week. So that, I mean, because it is not having third exercise. In fact, I am sorry to say this, the Bennett judge here declined to dismiss the CRP and all. That time, that my letter friend had said, saying that what the record speaks, that is contrary to what the things have taken place in the court. Then we have said, then I have.
All right, let us stay be for a period of 2 weeks.
Yes.
Next.
Whatever date you want to take.
Next.
Item number 70, today, speaker services.
Is not there online.
No.
Yes.
Madam,
Yes.
may
Yes.
am I audible, Lord?
Yes. Yes.
This was urgent couple of times, but even before vacation, they took time to get instructions. The only issue is about
Has the counter been filed here?
no, not file, but it was urgent for instructions. If your lordship sees the what do you call the docket, the issue, my lord, is that charge memos were issued, my lord, way back.
Yes. What have you received the instructions?
Instructions, my lordship, she approached my lordship earlier in the year 2016. A stay of charge memo. Lordship granted interim stay.
Already there is a stay in your own case.
And I am not on the stay, my lord. I am on the issue that out of 5 charges which were issued in 2016 and 17, they are still kept pending. And my lord, they are not finalizing the issue on one hand. And
because you have obtained stay.
no, there are 5. I did not obtain stay on 5.
Page number 2, last paragraph, amended paragraph last. Against the said orders of the CC and RCSTS Hyderabad, Srimati P. Kadile, they are the liquidator Jahan filed WP 37721 of 2016 requesting to stay the inquiry and also to challenge the inquiry officer as the junior member in the cadre of deputy registrar. The petitioner also paid the Honorable High Court that the instance of article charge memo Concern dated 4 to 2000, an officer against whom the petitioner has made complaint and who is vigilance against him is illegal. And the Honorable High Court has instantly granted interim stay for a period of 6 weeks on 3rd November 2016 in William Street in WP 37721 of 2016, and subsequently on 7/4/2017 the Honorable High Court extended interim orders granted earlier request.
All right, let them file counter with this now.
But I'll just say this, but I think lots are not properly appraised of the facts. My friend is saying the writ petitions that are filed are with regard to surcharge proceedings initiated against me on the ground that they cannot do so. Now, kindly have a look at para 9.
So anyway, this matter cannot be disposed of without the counter. Notice also has not been issued. Notice.
That's the instructions were asked because what is the present position, and then Lordships also asked me to find out whether I have made any representations. Representations have been made. For a minute, Lord, kindly have a look at para 9. For a minute.
The counters be filed in this matter.
Sorry, Madam. There is a representation, Lords.
Let the counters be filed. Let the counter be filed, then it will be decided.
But for that purpose only, matter brings adjourned, Lord.
All right. Notice before admission and then GP for services to 3 is directed to file counter list after 3 weeks.
Okay.
May I just say this, Lord, subject to this within this 3 weeks. Lord, there is a representation dated 14/8/2023 which I submitted because since 2015 charge memos are pending. I made a representation also on that regard. Lordship, meanwhile, Lord, can direct the respondents to consider that and pass orders within 3 weeks by the time they come.
What is the representation for?
Dated 14/8/2003. This is the what we charge.
What is the prayer in the representation? What is your ask? What is that you are asking?
Lord, I am asking a request you to kindly consider my candidature for promotion. I have filed it, Lord, along with the memo.
You have obtained stay of the inquiry. You have obtained stay of the inquiry officer.
Which, Lord, I have not. I have not obtained stay of the inquiry. My friend is totally mistaken. Kindly see, Lord, at page 11. It's not, I have not, the charge memos are not challenged. Kindly see para 11.
No, we'll see after. We'll see after.
Item number 71.
So far, representation can be considered. Because your Lordship is not saying anything positive. These 3 weeks, let them pass audits, Lord. If they pass audits, they will take into account all the issues and they pass audits.
Yes, let them do it. Yes. Next. 71.
71. Ramakrishna, GP for services.
Yes, at the request of the learned GP to file counter. List after. Tell me finally because 3 times I have adjourned only for your counter. How much time you want now? 4 weeks.
Item number 72. Venkana, GP for services.
But whether additional material papers. So yes, you have any objection to this IA to take this copy of these letters on record. The representation of the petitioner. Yes, IA2 is unopposed and is accordingly taken on admitted, allowed, and the documents mentioned therein are taken on record. Yes. Now your prayer is to dispose of your representation. Your prayer is to dispose of that representation, to direct the response. Yes? Yes, GP?
The forwarded the
yes, yes.
respondent can be forwarded to second response.
Yes, yes. In this resolution, the petitioner is seeking a direction to declare that seeking a declaration that the action of the respondents did not consider the application form 3 dated 15/12/21 in terms of GOMS number 317 dated 6/12/2021 for allocation of local cadre on their spouse quota, on spouse grounds as illegal and applicable. Those deputies. All right, CCTV. Disposal. Yes, sir, I said.
Number 73, Prabhakar Chikku, GP for Michael Nag.
You're for. You're representing. Next week.
And number 74, Bharat Shah, GP for Social Welfare, GP for Finance and Planning, GP for Services.
What about the counter?
Petitioner cannot show member of SK committee. They are asking me kind of fellows. The page number 13. This is 13. And make it type of topic direct. Page number 14 minutes. I think the candidates around 22 candidates were called for the post of that. And out of them, 3 candidates were selected. In that manner, my name is number 1, which is.
Yes.
If the request to the second and the obvious content is not being
All right, yes, you have been appointed on daily wage basis.
Then I tried only the question for the honorable referee. In fact, your tutorial is not applicable. In fact, your system whatever judgment is applicable to me because I have completed more than 10 years of practice without any intervention of the harmful photographs. Now they are rejected with 10 years. Page number 10. Now the person who are there are 3 persons that are appointed another. Another 1 person is the services were regularized. And another person, Venkateshwar, who was also appointed in the year 1989, his services were regularized. Because they approached the honorable court, their services were regularized. And in my case, they were rejected on the ground that I was legal. So Lakshmi Gani was page number 10.
Yes.
Permitted to pay from 11 bottom line, judgment of page number 11, judgment of the also Supreme Court of India State of Karnataka versus Umagini. The distinction made in Umagini between the explaining State of Karnataka versus Umagini. So on 10 nights, it is evident from the report that there is exception to the general principle against regulation limited to Umagini. The following conditions are fulfilled. The employee concerned should be work for 10 years and more newly sanctioned post without the benefit of protection of the interim models of any court of tribunal. In other words, the state government or its instrumentalities should have employed the employees and continued voluntarily and continuously for more than 10 years. In my case, I have been continuously working for more than 10 years without any interest.
They say there was no sanction post. It was not appointed against the sanction. There is no scope for regularization of service.
Only method they have that they expected they work for the 34 years. Now, and they have granted scale also. They are given increments, special for great scale. Now, the persons who are appointed along with me, that are annual permitted rate for them. The appointment of the employee should not be illegal, even if illegal. where the appointments are not made, continued against the sanction post, or where the persons appointed do not possess the prescribed minimum collection, the appointment will be considered illegal. But they are appointed me after calling the candidates and 22 candidates were participated, out of 22, 3 persons were selected. Now they cannot take a stand that my appointment is illegal. Since the petition was not appointed against the sanction post, if he fails in the bracket of illegal appointment and the appointment, the services of the persons who are continuously for a period of 5 years as well. In fact, I am not eligible for as per 0 to the petitioner has not completed 5 years of service. In view of the word, the petitioner that his case cannot be considered for regulation and it does not satisfy the conditions of 0 to 2. There are no
Yes.
These are the proceedings where the persons who are appointed along with me, their services, their regulation, regulated and they are given from the date of completion of 5 years. The last year, any fellows, certain drivers belong to the state of department in relation to subsequently against the card. Due to this kind of IFA scheme together with pay protection schemes shifted to depending. Then one of the last year, any fellows, they want 34. As such, the daily wage was in period of TH Ramlo driver, so joint director terms of M. Venkateshwar terms of K. Raghavu. K. Raghavu was appointed along with me. The year was recognized for purpose of pension only from 1/4/2003 to 8/4/2004, which occurred due to disbanding of IFID scheme on 7/3/2003 and the suspend and to that inputs to the next period was avoided. Mostly without any monetary request.
So they were working against some Kamati post and watchman post and cook post.
They were also appointed along to make me as a
driver, but then they were posted as though they were doing the driving work, they appears to be doing.
When the scheme is over, they will post. These are all things under the control of ITDA. Government is not the competent project officer. ITDA is the competent authority to regulate the services. If one scheme is goes, they will accommodate the another scheme. Now my submission is after taking extracting money for 34 years. Now they cannot invent a new method to deprive my rights. Apart from that, they have given scale, special rate scale, increments, everything is they are given except regulation of services they are and apart. My only submission is the persons who are appointed along with me and the persons who were appointed does not complete 5 years of service by cut-off date. Their services were regulated only on the day after the on-good code.
What are they saying in the counter?
Yeah, they have rejected on the ground that the same thing not illegal appointment is regular. My only submission may not be called as illegal or irregular. Because when came from backdoor method, was selection by the selection interview of the process. 22 candidates were appointed, 3 persons were appointed. It is not the case where I have been illegally produce some certificate or else.
Yes.
Selection process.
Yes, who is appearing for the respondent? Yes. But your statement still is working, no? Against what? Yeah. There is no sanction post. The past 30 years, there is no sanction post. Have you not recognized anybody else? The services of other persons, he was appointed in the year 1890. There are other people who got who were appointed subsequently. You have regularized their services.
He was also appointed in 1989. First, though the reference was taken, young maintenance of the other was appointed as driver on daily basis, follows on 7689. And in number 83 and 84, you are assuming kind of the declaration of this one is declaration of the limits of the group. It was appointed in 89. And the services were evidence for the coupon for estimate for ventilation law, as well as Apollo, both were appointed in last period. There 1989.
He is the third person. Another person also has been regularized. He joined later.
Ramulu and
Ramulu.
so far as Ramulu is
When was he appointed?
the last one. They were only is not the case that has to fulfill the apart from that one is and so far as one is construction goes for more than 10 years. And they are continuing without the protection of the court orders. And apart from that, my hand is shared minimum tax scale, increments, special tax scale, and the last permission and
Now let her say, you have made appointments, you have been taking their services, and now at this stage, if you say it is illegal appointment, then why are you continuing the petitioner? You want the services of the petitioner, but you don't want to regularize their services in spite of putting in more than 30 years. It's not fair.
After verification and
Selection.
what is the account? The stick has been taken saying that Ramulu and verification and TSHC was against the scientific the right basis. Whereas the stand taken against the petitioner. And it's too earlier these other persons that have approached the time. There was a direction. This was correct.
Yes. Come. What is this order in WP 230?
The service of the employees involved.
So this is with regard to the promotion. Regularization and then promotion.
Now,
Shall be taken into account for purpose of seniority, etc. Their promotion in the existing vacancies and further vacancies that shall arise shall be regulated based on these model regulations of service conditions specified thereunder. This is of 1997. Yes. So what do you want to say on this?
in this case, government had acted to regularize the services.
But they are not doing it, no. They have not done it. Yes.
Right.
Okay, it's open.
Item number 75.
143 of the deals with the same matter. Completed. Regularization, 143 item.
It will come when the seriatim only it will be taken up. Yes.
Item number 75. Krishna, Chief of Services, Chief of Home.
Termination orders. So this is based on mere registering an FIR. 10/9/23 the further police. Has a counter been filed here? It is coming for the first time. Notice. Huh?
इसका papers वेलेज है
Okay, what is that? These are the papers? What are these papers that you have filed now? Additional material paper. So that he wants it to be taken on record.
Yes.
You have any objection? Yes. The petitioner has filed a copy of the termination letter dated.
Item number 70.
What is the date of termination? 4/10. Then what is the date today? 4/11 today, 7/11. Yes. You have to take out notices, you have to serve on them, they have to file counter. 3 weeks. All right.
Item number 76. Chandra Sunkara, Ram Gopal, Chief of Services.
Yes, sir. Notice order in the. Challenging, what is this? Not operating immediately is downwards. Yes, so the petitioner of next month to scan for appointment is librarian. Yes, anybody appearing for the response? To get instructions in the matter. Yes.
For my instructions, there are 13 vacancies. They are offered the vacancies on.
Pass it over. Let us see if he comes with instructions.
In society, notification is issued by society.
Not society.
I think about the vacancy position, he had to get instructions. Pass over.
Item number 77. Ramesh, Chief of Services.
Notice order.
Yes, seeking for promotion at the post of deputy tehsildar in vacancy in the for physically added.
Yes. Have you got instructions in the matter?
Yes, 13 is the representation. I will follow the colleague will approve it. I will go directly to the presentation. For goods, six times, 106, the discharge for the physical handicap category.
So you want your representation to be disposed of?
Yes, madam.
In the representation, you have mentioned about the roster points.
Yes, madam.
Where have you mentioned?
Yes, 14.
తెలుగులో ఉంది, తెలుగు చదవడానికి వస్తుంది కానీ ఎక్కడ ఉంది అది? 6 రోస్టర్ పాయింట్ గురించి. ఈ ప్రమోషన్ జాబితా మొత్తం సంబంధించిన వీటిలో హోదా ఉన్న వాళ్ళకి you haven't mentioned anything about roster point here.
I mentioned
అవునా 6
సంబంధించినవి అవి నాకు రావాల్సిన వస్తు పాయింట్లు
all right, I'll direct them to dispose of your application. You're also a visually handicapped person.
Yes.
So same similar order as well. Yes. Similar order hasn't.
Number 79, final question. Emil Amaro.
Yes. The request of the learned counsel appearing for an official respondents who undertakes to file wakalat and also counter on behalf of the respondents. It's after how much time?
That is the prescription to be posted by the counter 4 weeks.
4 days. It's after 4 days. Serve the papers on.
The same list.
There is no other list other than daily list. That is the only. No, it's not in the urgent motion. It's in the daily list. It will continue to be in the same list. Yes.
Number 80, Bhagyasri, Chief of Municipal Administration, Chief of Medical Health, Prabhakar Rao.
May I please, Lordship?
Yes.
The present writ petition filed for seeking suspension of the GO number 58 of 2023, 10th February 2023, issued by the first respondent here in Milord, without having jurisdiction, Milord. In this regard, Milord, the petitioner filed the present writ petition, Milord. The petitioner initially appointed in the year 1999, Milord, in Medical and Health Department, Milord. From the year 2015 onwards till the date of transfer, Milord, that is 12/1/2021 under GO 317, Milord, the petitioner have no stigma in this regard, Milord. Without issue memo or show cause notice, Milord, directed the issued GO, Milord, that itself bad, Milord, due to that the present writ petition filed, Milord.
Yes. I think last time you were directed to get instructions.
Yes, Milord, they are not getting any instructions, Milord. For that, Milord, I filed the promotions are going, Milord.
1 minute, 1 minute. Yes,
Milord.
Order is necessary and representing on behalf of first respondent and actually for counter has.
No, counter you can file, but in prima facie also you have to show.
After hearing only.
Without, no, when you want to proceed with inquiry under 20, first initially you have to issue a show cause notice, ask the registration.
Notice before admission was ordered, the admission station and
27/4/23.
But after hearing only, we have to notice before admission was ordered, we have to file counter.
So how much more time you want for counter?
I'm sorry.
Number 3 of the GO says that the introduction mark is therefore held to submit later statement for his defense within 50 days. It is not proposed any action.
Now, before even coming to a conclusion that it requires inquiry, you have to issue a notice, call for the explanation. If you are satisfied, no need of taking action. If you are not satisfied, then you have to proceed. So that's what she's saying. No notice was given to me at all. That cannot be done. Not be done that way. So how much?
Promotions are, Milord, no, there is no need at all to file counter in this regard, Milord. If GO itself bad, Milord, the similar situated person already promoted, Milord, that is filed in page number 13 of fix an early date petition, Milord.
13.
Yes, Milord.
13 is
Separate IA, Milord. That is separate IA, Milord.
That is that separate IA.
Fix an early date petition, Milord. In that I filed all the material papers, Milord.
Latest change. Copies.
No, you have filed IA 2. So
In that page number 8 is my serial number is 35, seniority is 36, Milord.
Yes, Srinivasa. Kadamma.
No, Milord. 36, G Kishore. Page number 8.
36 is Mr. A. Srinivas. G. Kishore is 35. Okay.
That is promotion list, Milord. I am in the promotion list. Similar, page number 13, Milord. Similar situated person already promoted, Milord. That is page number 13.
13. Who is this person who has been promoted?
Same department, Milord.
What's his name? It's a Kamran Bey. Where is he? Yes. Is he junior to you?
No, Milord. All are equal, Milord. My promotion is not permitted due to this GO, Milord. I am entitled for as per GO number 257 of 1999, Milord.
No, how is he similarly placed as you?
He is also facing inquiry, Milord.
So where do you get that?
I get this only, page number 13 only, Milord.
13 doesn't say anything about the inquiry, criminal case or any inquiry against him. There is no reference to any inquiry against him.
The concerned, in the end of the page, Milord, the concerned officer requested to take further action and make necessary entries in the SR of the individuals under proper attestation.
So that is with regard to
even though Milord, as per GO 257 also the petitioner is entitled for the promotion, Milord. In that, Milord, orders were issued by the Milord. Guidelines and orders were issued, Milord.
Counter is already filed. No. 1 to 4 has filed. You have filed, Commissioner. Fourth respondent you have said on behalf of 1 to 4.
Annex 2 of this GO, stated that the additional collector of the reported that multiple complaints issued against the students of the class, multi-purpose app is controlled. Given right to Telangana, to access claim of against the Ramguna Corporation, when you worked in the Ramguna Corporation, after preliminary inquiry, it was observed that during the period.
All right, you consider his case for promotion at 257 if it is possible. Meanwhile, file your counter.
I permit to make one submission in this regard, Milord.
Wait, madam. Please wait. Yes.
For the benefit of petitioner, initially the petitioner was appointed in the medical and department, subsequently on deputation in the department. Thereafter, when he was repatriated to parent department. The allegation is that when the petitioner was in deputation, certain allegations were and the municipal department has issued the charge memo against the petitioner. Now the petitioner seeking promotion in the parent department, medical and health department. And the seniority list prepared by the director of medical health department is punished, and the one of the promotions given to one of the individual has been placed before the also. But the petitioner has not made the director of medical health as party respondent. But for implementation of the it may get though not the petitioner is eligible for promotion as per GO 257.
What about fifth respondent, district medical and health officer?
He is supposed to send the details to the director and medical health.
page 30, along with the additional papers, the
appointment of promotion of the
promotion filling of vacant post to the MPHEO zone.
Director of Public Health and Family Welfare.
The information is called by the director. The one of the individuals promotion, page 30, promotion is given by the director, Public Health and Family Welfare, Telangana State. Who is not the party before the.
Yes, madam. Now you have to make Director of Public Health and Family Welfare as party here.
No, Millard.
Then
I
who-
filed for suspension of GO 58 of 2023, Millard.
But you are asking for
Without issuing any memo or show cause notice, Millard. Kindly see page number 12, Millard, 11, Millard.
in the meantime, you want consideration of your case for promotion. Under 250.
Yes, Millard. I am ready to face any consequences if
All
the
right.
respondent follow the due procedure, Millard. Without
right.
following due procedure by the respondents herein, Millard, how the petitioner suffer for the further promotion due to their mistake?
All right. Now, will you listen to me?
Yes, Millard.
Now, you are seeking promotion in terms of GOMS number 257. Who has to give you the promotion? It is the Director of Public Health and Family Welfare. Unless until he is a party, a direction cannot be given to him. So you make him a party and come.
No, no, Millard. One submission in this regard, Millard. If
My
the
next
GO is suspended, Millard, I am entitled.
I'm not going to suspend the GO. You first make this person as a party and
Millard,
come. I'll
GO
direct-
itself bad, Millard. Without issuing notice, the GO issued by the government itself bad, Millard. Kindly see
Miss
13
Bhag-
of my writ.
Adjourning it to next week. If you want to make the party director a party, you please make and then come. I'll direct them to consider your case for promotion. Yes.
Item number 81, Surendra Reddy, Chief of Services.
Rejecting the request for the petition of the petitioner for stepping up of pay on par with his juniors. Yes. Counter is filed. You don't have the copy? Tomorrow. All right, tomorrow.
Number 82, Bill Krishna, Chief of Services.
No Passover in this case. Already so many, the PV Krishna gaరి case కాదు ఫైల్ ఇచ్చింది అంటే కొత్తగా నార్త్ No objections. The file counter next week. Next Monday. Tomorrow in the same list. Daily list.
Item number 83, Vikram Chandra, Chief of Services.
There are so many matters today at 2:30, so no time for retirement benefits and PF gratuity. Not considering the representations. All right, tomorrow.
Item number 84, Kamala Kadal, Chief of Education, Sneha Charity.
Yes. Have they filed any counter? Counter. Huh? Government has to file counter? You're working as what? Lecturer in and is it necessary for a second respondent also count is necessary? And find the counter. 2 weeks time. As a request of the London Council for the respondents. Number 2. GP, 2 weeks.
20th November.
Hmm?
20th November.
20th November.
Item number 85, Shashidhar Reddy, People Services, Nathan Reddy.
May it please your lords. Milord, I am permitted to Milord represent in this case. Milord, my video is unable to Milord open. Milord, camera is not Milord, unable to access.
Okay.
Milord, this writ petition is
1 minute, yes.
Milord, this writ petition is being
1
filed.
minute, Shashidhar Reddy, 1 minute, yes. What is the issue in this petition? There's an amended prayer. Have you filed your counter? Yes. Counters have not been filed in this petition.
Milord, respond number 1 and 2 file counter. Milord, respond number 3. Milord, this is a college. Milord, deliberately Milord avoiding to file counter. Milord, Milord, the issue is Milord very simple.
Counters are not on records, even of the 1 and 2. Will take
Milord,
what is the issue here?
Milord, the respond number 2 Milord issued impugned proceedings Milord dated Milord 12/7/2018 and 12/2/2019 Milord redeploying the petitioner from Milord parent college, respond number 3 college to government degree college Milord. That must be Milord a temporary basis based on GOMS number 890 Milord dated 2nd August 1996 Milord. Milord, without prior approval of the government Milord, the respond number 2 Milord issued the impugned proceedings Milord. Milord redeploying the petitioner Milord, despite being Milord maintaining the Milord economics Milord as required strength in the college Milord in the BA, BCom and BSc courses Milord. Milord, the consistent Milord student strength were there Milord with regard to BCom, BA and BSc.
All right, the counter of the respondent is necessary.
Yes, Milord, but they are taking time every time. Milord, last occasion also, Milord, they said that Milord, it is about to Milord put their signatures in the counter, Milord. Last may fix Milord date, Milord.
Next week, how much time? Finally, at the request of the London Council, representing the third respondent to file counter. Finally,
Yes,
yes.
a week days, Milord.
2 weeks, 2 weeks.
I am obliged, Lord. I am deeply obliged.
Yes, appreciate. No passport. Promotion matter counter is filed. At the request of the learned GP for services. 1 to file counter, list after 3 weeks.
Item number 87, Angopal, People Services.
Hmm. So counters are necessary in this matter. Counters are not filed. Let them file counter. 2023. 10/4/23. Yeah. All right.
The promotion and transfers.
For counting the respondents. Mr. After how much time? 3 weeks. ఎక్కడ అవుతాయి ఇప్పుడు ట్రాన్స్ఫర్ ఎవరు తీసుకుంటున్నారు ట్రాన్స్ఫర్స్ who are undertaking now let the elections be over, let them do it. Yes, 3 weeks.
Item number 89, Srinivasa Maharaj, People Services, Babu Rajendra Nisar.
Yes. IAS, you are not a necessary party in the disciplinary proceedings against him. You may be a complainant. It has been taken note of, and he has. They have initiated action against him. But that you should not.
He has been deliberately rejected his case. He has not taken his relative.
He has withdrawn his allegations against you.
But for me, not my case, unfortunately. There is no evidence, but still the name has been
That he has already withdrawn, that has been allowed. Withdraw, your allegations against you have been withdrawn. You are, in your, Mr. Please, in your presence only, the order was dictated dismissing your application for impleadment, and also I have recorded his submissions for withdrawal of his allegations against you. So, period. If you want, you are not satisfied with the order, you can do whatever. But now that order is already there. In your presence only, I have dictated the order. I remember that. The order has been passed.
This was an order of 3 days. This call. This was an
You have to file a CD and take it, it seems. You should know the procedure.
The charge memo, page 22. In the first charge, 23/10/2012.
Does the other respondent file counter?
1 second.
Then-
They have not been out for admission for ISP.
Not heard for admission?
When they have taken admission, he took an objection, then he I file again, then 1 second, then Russell can on the new order.
Yes.
Page 22 is dated 23 initial charge was given to the petitioner. On the ground that not has initiated the regulation 17 Page 23 is the charge.
Notice was already issued, notice before admission. On that day itself, after passing the order, I have issued notice. Learned Council, Government Pleader for Services 1 takes notice on behalf of the response 1 and 2 and gives further notice. So,
Urgency, why I just said.
what is
I
urgency?
challenge this channel. On the ground of what charge has been dropped against me. Now they have reopened the charge for same charge and wanted to initiate a present against me. Challenge is that right. Because stay out. They are proceeding with the inquiry. I only say, let them not pass. But the issue is that.
What have they done to do?
They have appointed the inquiry officer.
Where is that order?
Now, inquiry has been completed. Now they wanted to initiate action against me. I only say that pending expedition, let them not take any final order because it is a case of my case is that member itself is illegal. Therefore, let them be stay for not filing final orders on the inquiry report. It's my humble submission.
Inquiry has been completed?
Yes.
How do you say? When was the inquiry conducted?
Inquiry has been, report has been submitted. 4/11/2023.
411.
Because initial expedition, they have completed the inquiry, submitted the inquiry. I fully submission, let them not pass any final orders.
Is directed to submit his written representation, if any, on the inquiry within a period of 15 days. This is dated 4/11. So 15 days, there is still time. They haven't done anything.
They are hurried to proceed with their.
They'll have to wait for 15 days, no? Once they give the time. They have to wait.
If anything happens, but in fact, my humble submission, the charge itself is not able to be continued. In my humble submission, let them not pass any final orders.
All right, yes. The learned government leader. Yes. What are your instructions? Yes, what are these instructions? File your counter. Okay. The learned government leader seeks for the time to file counter. Yes. Furnish the copy of. That is 4/11/20. The commissioners have been. Post after 2 weeks. What is the date after 2 weeks? Huh?
20th now.
20th. Yes.
Item number 90, Gopal Government Chief Verification. Suresh Ram.
My lords, I am appearing virtually, my lords.
Delete the name of Mr. Babu Rajan. Yes, Mr. Suresh Ram, yes.
My lords, I am here, my lord. We have filed a counter and a vacate also, my lord. Lordships were not inclined to grant an interim order, but lordships instructed us not to take any coercive steps till
Yes.
2nd of November. That's where it is, my lords.
Both of you don't speak together. What is he submitting? Only that he has filed a counter and that, I have directed them not to take any coercive steps. Have some patience. Yes. Now that they have filed counter, you are ready with the matter?
However, their objection is that to maintainability of the school. In another repetition, your lordship heard the matter and the matter is resolved.
Yes.
And my IA is for suspension of the suspension order. Is my submission. With regard to maintainability, the submissions are
Subject to the outcome of the other repetition, whatever.
So maintainability is concerned. I understand I may not go in this matter. And with regard to the suspension order, your lordship has rightly passed orders not to take coercive steps. With regard to the main order which is impugned in the matter, that is show cause notice issued with a predetermined punishment. Your lordship has rightly passed an order not to pass any coercive steps. In this case, my lord, the respondents have issued a suspension order lot, case which are filed in IA, stating that the suspension may be revoked or suspended for 2 reasons. Under the rules, there is no provision to suspend the petitioner. When your lordship may ask earlier.
Where is the suspension order that you are challenging?
Is that
Page number 27.
not 410 is the suspension order?
Page number? Page number 27. Yes.
The lordship may kindly see the suspension order they have issued. Your lordship may see the second paragraph. Further, the charges leveled against you by show cause notice referred to 3 above are serious in nature. Therefore, you are hereby. This is the notice I have impugned in the main repetition. Hereby suspended from duty with effect 5th October. The notice which I have impugned in this repetition, my lord, stating that.
This is with regard to that corporal punishment.
Yes, my lord. They have directly said that they are going to impose the major punishment of removal.
Where is that?
Well, that is the previous order. That page 17. Your lordship may see para 2, my lord. Para 2. The said inquiry report was placed before me for examination and to pass necessary orders in further. Peruse the contents of the inquiry report and observe that you are guilty of the charges pressed against you and that it has been proved that you are committed. I have placed before your lordship in a similar matter where I have placed law. The judgment of the Madras High Court lord following the Karnataka's case where show cause notice is given. Please and pass on your lordship. In this case, the Madras High Court has followed the decision of the Supreme Court in Karnataka's matter, my lord. In 1993 post SSC, the Supreme Court has held that an inquiry report in a residential proceeding.
No, was the child injured by?
No, the child was not. It was only, and recently the Bombay High Court also has issued a judgment, my lord. I will place before your lordship for one hearing, my lord. Where it has held that we are giving punishment to put the children for discipline and not having qualified intention and not causing injury. There is not amount to corporal punishment. And your lordship may kindly see the rules, my lord. I have also given last occasion the switch disciplinary and repeat rules of the employees of HP High School 2002, my lord. Your lordship may kindly go to 6, which is that the numbers are pages are numbered, page 50.
The suspension of a.
Suspension of employees shall be resorted to. When disciplinary proceedings are contemplated or pending, or when a case in respect of any criminal case is under investigation, trial, or inquiry or trial. This is a case, my lord. It is not a case where a criminal investigation is pending, my lord. And more so, admittedly, the inquiry also is completed, my lord. This suspension order is in the nature of punishment, my lord. My submission is the entire inquiry. And she is a teacher, my lord. She is a teacher, my lord. She has imposed the punishment. Even the videos which were placed before the inquiry, my lord, only show that she has stabbed the child. She has stabbed the child. And also there is no complaint of the parent showing that she has anyway injured the student. The child was running out of the school. The explanation also, as she has told, 3 times the child runs out of the classroom. The child is told not to. And when the child has repeated, she patted the child. That is all she has said. And one more submission is not in the school. If you have not stated in the affidavit, all the permanent employees, all the employees who are going, who have been working in this school for a long time, the management appears to have adopted a measure to remove them by indulging them in such activity. It is not that never before such charge memos are issued. The petitioner has submitted with the names in the writ affidavit that similarly 5 other teachers were also given charge memos. But those teachers who are highly influential, who could influence the members in the board, no inquiry is conducted. Clearly, they say, counter, they say no such thing is that strict to prove. The petitioner is strict. The records are in management law. They do not deny that these persons were not issued the charge. My only submission is not she is a Telugu teacher. She conducts that. Even the parents are calling the teacher. Your Lordship, here the matter disciplinary inquiry is concerned where the petitioner has raised the issue of bias by the management.
In this situation, you have only raised.
Yes,
Action is only against the suspension order.
No, I have challenged the main petition. I have challenged the show cause notice issued along with the inquiry report. The Lordship may suspend the suspension order. Your Lordship may was the matter for hearing, not another petition also. Same charge memo. Your Lordship may pose the matter for hearing.
So there is another petition filed. No, there is another petition filed by the very same petition.
No, not same petition. Another teacher.
That's a different.
Yes, another teacher with regard to corporal punishment. They are just giving the charge memo. The next day they give the notice. The next day the inquiry is conducted. The next day they are given with objections with a show cause notice saying that major punishment of removal will be given. These are the teachers who have worked in the school for more than 15-16 years. The earlier teacher has worked for 18 years. This teacher has been working for contract based also. All the service rules are applicable even for according to the service contract. Achievement considering the interest of the students and all the teacher because inquiry is completed. The very purpose of suspension is they do not match any of the evidences in the inquiry below. There is no such situation in this case below. And one more submission, even in the suspension order, it is clear that the order is applicable to disciplinary committee. The petitioner submitted to disciplinary committee, but they refused to receive it, saying that there is no disciplinary committee, and they said you give to the secretary to the Board of Governors. The petitioner has addressed. The petitioner has sent a register post also, which is returned as refused. There is no appeal also to the petitioner. The Lordship may kindly tell us. It is written saying refused. The suspension order, Your Lordship may see in that they mention that the appeal is to inform that you have the right to appeal against the orders passed herein. You may exercise your right of appeal before the Board Committee of Disciplinary Proceedings under the disciplinary rules. Only a teacher will not situation where the petitioner material with any evidence or anything does not rise, my lord? Teacher only conduct the classes.
Yes.
And she has given a letter undertaking to the principal the very first day when a notice was given to her, saying that she will not take any such action also even if students are not maintaining discipline. She has given that undertaking also. It is not a situation where
Yes. Yes, Mr. Suresh.
My lords, before I commence my submissions, my lord, I would request your lordship to see the video clippings of how this teacher has indulged in corporal punishment. Perhaps that will clarify a lot as to what this teacher has done. My lord, I'll get into each of those issues that have been raised by my learned friend with regard to transparency in terms of how the inquiry is conducted. I have handed over a copy of it. My lords may examine it. I know we just have another 1 minute to go. My lords may see the videos.
No, we'll take it up after lunch.
Very well, my lords. I'll be there for physically. I'll come and appear. Very well. Obliged.
Yes. Yes.
Item 71. Mr. Basman, master proposal for 1 week, master proposal for
I think their counter is necessary.
No.
71.
Something the charge memo of the position of the
I have issued notice for them to file counter. I have given up 4 weeks.
1 week.
What do they want to file counter? Is it for counter? Yes. GP? For counter only.
2 weeks. 2 weeks.
3 weeks. 65. Yes, you were not there. None of you were there. Now, so many councils are there, not one being present. There should be some representation. I have extended by 3 weeks. No, implementation, I think somebody objected to. I do not. He wanted implementation to be allowed or. No, he said he has filed counter to the implementation. Anyway, I have already adjourned by 3 weeks. 119. Oh. Who's the other side?
I already informed the other side.
Ah, 3 weeks.
After the hearing, already has project for extending interactions from date for hearing.
Item number 60. After the start in the morning.
Now you are also in the subject.
It's after 2 weeks. 2 weeks. 2 weeks.
Yes. Interactions, okay.
Interim order granted relations and extended. Yes.
Before the council starts, I just.
Follow out the case, please.
I'm sorry.
People should know which case we are going to take up.
Continuation.
Continuation of hearing. Item number 90. Gopal Ramachandra, Chief of Education, Suresh Ram.
Proposing to show the entire videos. I have no objection to the watching the videos to us. I'm not ready to. My only submission is, my repetition is filed. The main repetition is filed challenging the show cause notice, where major penalty has been given with a predetermined punishment, the notice is given is my case. Going to the evidence of the case is concerned, the scope enlarges. And we are at a stage where the show cause notice is given with a predetermined punishment, which I am challenging placed before your lordship, placing before your lordship the Supreme Court judgment conducted case, which is also relevant by the Madras High Court, where in such case the inquiry notice is similar situation the court has considered. And my IA is concerned a lot is with regard to the suspension. And suspension is concerned, I have shown to your lordship the provision where the respondent has no power as of now to raise the issue suspension order. And the second ground is that there is no remedy of appeal as there is no committee. Those are my submissions. And the lordships are hearing with regard to what is corporal punishment, what would constitute a corporal punishment. That may go beyond the scope of this regulation. That is my hunch. That is my submission. And
No, that may be. What is the issue? What is the company? All that is another thing. The objection raised by her with regard to that the authority did not have the power to issue the suspension order, and you have issued the show cause notice with a predetermined mind. So if you answer those two, and then later on we'll see if necessary.
Lord, I just would like to pass this on. The maintenance of the corporal punishment orders. This whole proceedings begin with the parents. Jivansh Reddy, a boy of 4th class child. To beat them on the sensory parts of the growing children. It is a pack of allegations saying that if you are hitting the child on the head, pulling the ears, those are classified as corporal punishment, which is very serious. Hence the proceedings. Proceedings, because I only requesting lordship's video because that will clarify the position and answer lordship's question with regard to
no, I don't.
whether there is a predetermined thought processing punishment. Law with regard to the house is what is the process that has been initiated? It was found that upon a parent's complaint, show cause notice was issued. Did you indulge in this? An explanation came forth, and a reply was also given. That reply was not satisfied. The teacher simply said, I have only to discipline the children. The Juvenile Justice Act defines what is corporal punishment. Because the seriousness of an offence has to fall from the rules. The society has its own disciplinary rules. The learned is different. And 2 objections sustained. One objection, your lordship aware, writ is not acceptable against it, so that I have argued it like. Well, that will continue. So far as the other thing is, she availed the benefit of appeal. When appeal is also sitting on, she says that the appeal committee is not examined. Committee has received it, issued an acknowledgement.
But then she has shown the copy. Where is that acknowledgement?
What we see disciplinary proceedings, they filed an appeal. But also primary number 28. They do it for
28 of?
28.
of the
Find out
retention.
13/10/2023
Ah,
to the committee.
ah,
The law specific
13th October. It is dated 13th October.
13.
Ah,
Appeal has been filed and this has been received. Now, we see the opening page, secretary view also. Now, we see endorsement on it, signature.
But when she has sent it by post, why did you refuse it?
We did not.
The endorsement is that. The endorsement is not made by the petitioner. It will be done by the postal authorities.
Oh, no. Mostly received. She also parallelly filed a hard copy. That copy is with the appellate authority. An appellate authority committee has to be constituted by the board. They will constitute and sit. The proceedings here to come in. To arrive at a suspension also, inquiry was initiated. Petitioner, transparency is what.
Who is the authority to place the petitioner under suspension? Number one.
Respondable. This is as per the rules.
Show me the rule. Show me the rule.
Principal has part.
Please, you will not. See, when you were arguing, he did not interfere. When he is arguing, you are not supposed to. Let him complete. Yes. At every stage, if you start answering, then. Let's file this copy of the rules, disciplinary and appeal rules for the employees of the.
Those rules are not everything for them. Because we see this called disciplinary appeal rules, the employees of the office. I'm answering this question as to the principle any system. That's all the question. Without basically the appointing authority, then definitions under 2. There is appointing authority and disciplinary authority.
Yes.
We'll also define disciplinary authority means authority competent as rules to impose an employee or the professional penalty specified in the rules. But we now see the definition of principle. Both the principles have been provided at 8. This part number 2. Principles of the speech.
It's 7.
Yes.
Principles means principles of the.
Who is 7?
What is 12A9 of the rules of the society?
I'm coming. Before this, I also examine what are the penalties that are prescribed. We'll also find it page number 6. And there's a procedure provided at 7 and 8.
No, I don't have all those things except for the suspension order.
The complete rules are not comprehensive.
No, she has furnished only a copy of part 4.
There are
Suspension.
There are 4 parts. These rules I can use.
So part 4 is before me. With regard to suspension. Yes. So suspension is not a punishment.
Not a punishment. It's furtherance of an inquiry. She's entitled to subsistence allowance and that has been granted. Lord, even after inquiry is initiated, since beating of the child is a major issue, one acted for a complaint to the parent. An inquiry officer is appointed. The petitioner participated in it. Produced whatever she wants to say, she said. In fact, an explanation was that I was only patting. That's all the language she used. I was only patting the check. Which is why I requested a lot to see the video. Because those videos are clearly prima facie will reflect. If an authority is examining this issue, prima facie if you see a child being beaten up. Not in any form. Because I also brought the definition of the video copy file also to permit. Under the Juvenile Justice Act, we follow the rules of the suit. Under the Juvenile Justice Act, corporal punishment, because in furtherance, because if I am trying to discipline the child, my last friend was saying discipline the child. Section 2 of 24 says corporal punishment is legal, but I just let's have it. I just read it. What is the significance of this? Right? Management has no issue to suspend a teacher just like somebody who's qualified well, right? Because classification if I was arguing matters. Qualified teacher who can teach well, who would always want to retain. But once children are subject to any sort of this is assault, imagine an adult being slapped. It is an offence. First, you intimidate another. It is an offence under IPC 506 509. Here, a child is being pulled and beaten. Prima facie, that's seen from the video footage, which none of the teachers, the witness examined an inquiry. Disputed this fact, including the petitioner said, Lord, I beg this honorable court once to see the video, because that is that. Because I only am making the sentiment because I come to this. Lord, I know the definition of corporal punishment. Corporal punishment. Lord, these are small children. If the parent sees, the parents will go paranoid. There are multiple videos of this teacher indulging in this. But all schools are under mandate not to punish children. See the manner in which she's beating them. I read out the definition. Not even me, I have grown up in times where punishment was there for every one of us from the definition of it. Not today, because beating is such a thing, it has a mind and impact on the child. Brilliant child, we do not know, but subject to assault and torture constantly by teachers or even a peer psycho. This is what the act of the teacher is. Not corporal punishment, because I learned this instead. We did it discipline the child. This is prohibition. It's a prohibition. 24, my lord, you see the subsection. Corporal punishment. I am looking at children justice. Lord, there are multiple videos. I only saw one video. Multiple videos are there to demonstrate clearly.
These are the rules, Act 1.
You know, I just passed. I highlighted it.
These are the rules.
When I will read this, that any act by a teacher indulging in any act of assault any sort of way, I just highlighted it. In furtherance of disciplining the child, this is classified as an offence under 82. Whereas I put a post there also. Whereas we see section 82 in the Juvenile Justice Act. It's an offence. And if this management does not report or take an action, the management will be penalized. There is a sentencing, may take out section 82.
Yes.
82. It is an offence. And this aspect of it, prima facie reads it against the petitioner. So far as showing what will the principal do? The parents are constantly at the principal's office. Why is my child beaten up? Why is the management sleeping? Parents are not aware of the provisions of law. This I made an endeavor. Bring it to your lordship's notice to understand what is the whole issue with regard to the law of corporal punishment. But this being the case, show cause not to see the entire sequence of events that went by. Because the grievance of the petitioner is prima facie saying no transparency, no predetermined punishment. In fact, I will also refer to a 5-judge bench judgment of the Supreme Court. It said, if there is no question of predetermined punishment, it is that the disciplinary authority have listed out the punishments which they may impose, and yet the whole thing has to complete. At the premature stage, you don't interject and stop the proceedings. Supreme Court is clarified. I also rely on this judgment which I got for your interpretation. It's a 1958 judgment, 5-judge bench judgment, regard to the whole concept of predetermination of punishment. But I will come to this judgment in a moment's time. Because my friend is saying, challenge the very show cause notice, suspension or everything. Prima facie showing what do we do? Management also will be sued. Juvenile Justice Acts will take the management and they can be imposed a punishment for management not taking an action to prevent such kind of thing. This is the issue. But we see the judgment. Lord, it begins from paragraph number 11. 11 to 16 paragraphs are relevant. Not the context, I say it. There was one employee working for the government of India who was indulging in a private business. So the management issued a show cause notice against him. This is in that context. And that show cause notice was sought to be challenged. The Supreme Court 5 judgment observed that allow the management to conduct an inquiry as to proceedings. You cannot raise an issue. I just read out paragraph number 11. From 11 on. It won't take much time. Let us examine. This is the context where it is a state or a center. Article 311 will come into operation and 311(2) they say was not complied. That is where the context of this judgment comes. 11. Let us examine it more carefully what constitutes will follow Article 311, who requires in every case the context of actual punishment to be inflicted on the government servant. Concern must be mentioned in the show cause notice issued at the second stage. It is obvious that Article 311(2) expressly says that the purpose of the issue of show cause notice at the second stage is to give the government servant
concerned reasonable opportunity of showing cause why the proposed punishment should not be inflicted on him. For example, if the proposed punishment is dismissal, it is open for the government servant concerned to say this representation that even though the charges have been put against him, he does not merit the extreme penalty of dismissal, but merits a lesser punishment. Such a removal or reduction in rank, if it is obligatory on punishing authority to state that it will show cause notice in the second stage, the exact or the particular punishment which is to be inflicted, their third notice will be necessary if the state government accepts representation of the government servant concerned. This will be against the very purpose for which the second show cause notice is issued. Paragraph number 12. Then there is another aspect to the matter which is pointed out, which was pointedly emphasized by Tulak Jay. In the present case, the show cause notice had merely stated the punishment of dismissal without mentioning the other two punishments. It would still be open to the punishing authority to impose any of the two lesser punishments of removal or reduction in rank, and no grievance could have been made either about the show cause notice or the actual punishment imposed. Can it be said that the enumeration of the two punishments of show cause notice invalidated the notice? But this is relevant. What is there? What is sought to be said? It appears to us that the show cause notice in the present case, by mentioning the three punishments, gave a better and a fuller opportunity to the appellant to show cause why none of the three punishments should be inflicted on him. We desire to emphasize here that the case before us is not one in which the show cause notice is vague. No, that's not the case in the present case. Or such a character as to lead to the inference that the punishing authority did not apply its mind to the question of punishment to be imposed to the government servant. The show cause notice dated April 11, 1954 stated in clear terms that the President is provisionally of opinion that a major penalty, namely dismissal, removal or reduction, should be enforced on you. This is what has happened. Post inquiry is noted, commission is given. What do you say? A plea bargaining exercise, which is not prohibited in law, which is given in transparency, all reasonable opportunity. Therefore, the President has come to a tentative conclusion that the charge against the appellant merited any of the three penalties mentioned therein, and asked the appellant to show cause why any one of the aforesaid three penalties should not be imposed on him. We see nothing wrong in this principle in punishing authority, tentatively forming the opinion that the charges proved merit and any one of the three major penalties, and on the footing asking the government servant concerned to show cause against the punishment proposed to be taken in alternative in regard to him. To specify more, the one punishment in the alternative does not necessarily make the proposed action any less definitive. On the contrary, it gives the government servant better opportunity. Will not this also be relevant? A better opportunity to show cause against each of those punishments being inflicted on him, which he would not have had if only the severest punishment had been mentioned and lesser punishment not mentioned in the notice had been inflicted on him. Paragraph 30. We turn now to certain decisions on which the learned counsel of the appellant has relied. So on and so forth.
No, it's okay. The judgment is only with regard to
predetermined aspect, because emphasis is laid on it. I am actually saying what transpired here was we see from the beginning, the magistrate's entire proceeding, what is sought to be challenged for the online principles of natural justice violation.
It is a show cause notice.
The show cause notice is at page number 52. Show cause notice 50, page number 52.
We have gone through the CCTV footage, so it was probably.
CCTV footage was examined prima facie. But at the inception, the respondents have not committed any error. And in fact, prima facie, despite there being prima facie, to satisfy the rules, notice is being issued. The inquiry was followed. Ample opportunity or all support. But even at the stage of suspension, punishment to be imposed.
First show cause.
21st July?
7th.
Right? 28th.
Date 17. Date 17 is the show cause notice.
No, madam. This is not a back end proceedings. Not a predetermined aspect is coming here. My laws have asked me where has it begun. I wanted to write.
21st July 2023 is the first show cause.
20th first, 20th. Correct, Lord, 21st July is the first show cause notice. Reply came back, explanation on 24th July. And a rejoinment from the second show cause notice went on 24th July, again the same date, appointing the inquiry officer. There are procedure all throughout has been applied with prima facie knowing what the petitioner has done. There are the notice which is thought to be challenged. My lord, you see in page number 19. My lord, this is where the predetermined issue comes in. My lord, may read the entire notice. An inquiry is completed, findings of inquiry is come out, submitted to the authority to take a decision.
Yes.
My lord, now is page number 17. My lord, this comes to the last because there is a rule which says that you ought to inform the petitioner before a punishment is imposed. You not render judgment. Then it's an ample opportunity for them at every stage, my lord. Show for us, you have an explanation. Then you have an inquiry, you have a right to plead in your defense. That should be exhausted to the fullest. And findings are there prima facie in the video recording. Thereafter, the principal says, now an inquiry report is coming. What do you say about this? At that stage, they want to challenge it, my lord, in my humble submission. If this is the law that has been laid down by the Supreme Court, you should allow the procedure to unfold it. You cannot come and interject at every stage and stop the process of proceedings. There are ultimately a provision of appeals there. There are, while alternative remedies been invoked by the commission. Whether now that proceedings will unfold, she has a right to even contest there also.
Does she submit her representative to this or objections over the inquiry officer?
This objections, I have not been submitted.
Not been.
Objections are not. Lord, may I just say this? This letter of the 6th September 2020 is only indicating that you please let us know because it's a question of plea bargaining. My lords would observe 2018 lot of plea bargaining concepts have been brought into English proceedings. Administrative law runs on a very fundamental principles of fairness and transparency. And even before somebody's punishment is sought to be imposed, a plea bargaining can come in. In fact, all throughout my lord's Miss replies, she says, I apologize. My intention was not. My lord, may see the very first reply which she gives.
Yes, yes.
My lords have seen all that. She says, I apologize, I did not mean. Page number 50. My lord, the petition is constantly saying this. My lord, till date, the parents are coming and saying, why no action is being taken? Should we alternately go against the management? My lord, I'll face another round of it. Management is falling under heavy pressure. My lord, for all practical purposes, the entire institution is under scan. No teacher, without a similar repetition as a gentleman at 5 Mr. 3 hours, he makes the children stand on the bench with the hands lifted. Will not read the definition of corporal punishment. Alternative recourse has not been made by the parent. They say, please take an action. If you beat the child on their neck, the very sensitive, they're still around, they'll be in growing stage. It can lead to spasm. And instances today, because reporting is happening, that children when beaten up are shown across. Well, if I were to play all the video clippings for whatever has happened, well, also you'll understand what's. Despite procedure we could have not ignored, but with the rules we cannot cross it. School has chosen to pass through a transparent and arrived at this juncture, and no punishment is due. So there was no informity in all practical. No rule has been violated. But I'll lay heavy emphasis on the judgment, Lord, which clarified that at every stage if it comes on a simple, unsubstantiated plea that principles of natural has been violated. The petition is participating also. Lord, I have nothing better to say. At this juncture, I have another petition to also say on the same line. But otherwise also, because these are matters where driven by conflict. But I leave the rest of the courts, Mr. What my learned friend says. No procedural informity at all.
Yes.
That procedure is not. I have submitted. First, the teacher is given a show cause notice. Teacher submits an explanation saying that she is only patted and is not given any punishment. And also, there is no complaint of the parent saying that the student was injured or caused any pain. My first submission is this. And with regard to what is corporal punishment is concerned, say, submitted before your lordship's mirror may not be subject matter as at this stage. And if the parent who has given the complaint is not examined to know if the child is suffered any injury or pain. The teacher who is working in the school may not sincerely extended an apology. That doesn't mean that she admits that she has imposed corporal punishment. She has apologized for the reason that even if patting is to be considered as that, she says that I apologize and I will not do that also in future. That would be the meaning of the apology letter what she has given. The apology does not mean that she admits that she has imposed a corporal punishment. Is my submission. And with regard to how many times the petitioners will be coming to the court, that cannot be questioned by the council, my lord. As and when there is irregularity, my lord, the petitioner has a right to approach the court process. And in this case, my lord, the dates from when, how the series, just now the council has taken your lordship through, my lord, it shows that how quickly it has been done. And moreover, the parent who has given the complaint ought to have been examined by the disciplinary authority. And the petitioner's grievance is that the entire inquiry is being conducted in a biased manner. The second thing is that the notice clearly shows that the authority has a predetermined punishment. There is no alternate punishment also. The letter in clear words states that the charge is proved and the punishment to be imposed is that of major penalty of removal.
That is after the inquiry, isn't it?
The inquiry.
After the
that is on the 6th. No. Whatever you are saying is about the major penalty.
Yes.
Is mentioned in 6th September 2023.
In this, Honorable Supreme Court, in Karnataka's case also, my lord, has dealt with the final show cause notice, wherein the punishment was also mentioned, which the court held that it is a predetermined punishment. Your lordship may see, your lordship was probably last occasion I asked for this. And read and
I think it's good.
government that's HIGHCOURT lot in case of the register Anna University and the team.
Oh, I think it's not there. You have to be there.
The lordship, obviously, I'll read and pass on. Wherein the Supreme Court judgment also is referred, I'll read that and then refer to what has been. Managing Director, ECIL Hyderabad versus V. Karnataka and others. The Supreme Court has held that requiring report in the cities is required to be punished delinquent employees so that he can make an adequate representation. In para 29, the Supreme Court has held so exo service. Hence, it is to be held that the inquiry is not the disciplinary authority. Inquiry officer is not the disciplinary employee. Has the right to receive a copy of inquiry officer's report before the disciplinary authority arrives at its conclusion. Here, a disciplinary inquiry is conducted and the report is given to the authority and the authority communicates along with the inquiry report. He is noted saying that he is going to impose this punishment. At its conclusion, with regard to the guilt or innocence of the employee with regard to the charges leveled against him. Right is a part of employee's right to defend himself against the charges leveled against him. Denial of inquiry officer's report before the disciplinary authority takes it before the disciplinary authority takes its decision on the charges is a denial of reasonable opportunity to the employee to prove his innocence and in a breach of principles of natural justice. In the relevant rule relied upon by the respondents is of the year 1980 in this present case. Since the law has been settled by the Constitution bench, the rule which has been invoked prior to that cannot be applied, and as per the dictum of Supreme Court, it is mandatory on the part of the disciplinary authority to serve a copy of the inquiry report to the petitioner before the disciplinary authority takes a decision on the finding of the inquiry officer, calling upon him to submit his explanation for the inquiry report. In this case, admittedly, that is not done. The inquiry report is given to the petitioner along with the show cause notice calling for objections with a predetermined punishment. Admittedly, copy of inquiry report was not furnished to petitioner. Non-supply of the inquiry report in the instant case is considered opinion of the court would amount to petitioner at this juncture. The learned counsel for petitioner submitted that now a copy of inquiry has been furnished to the admittedly the resolution of syndicate, which has been the basis of issuance of show cause notice, reflects that the syndicate has predetermined the punishment to be imposed on the petitioner. Thus, it requires interference at the hands of this court. Consequently, the impugned show cause notice is liable to be suspended. Therefore, both the resolution of the syndicate and the show cause notice refuse the liable to disciplinary authority to proceed with the disciplinary proceedings. Fresh inquiry is directed to be ordered. My submission is not. One is not mere
giving of apology as is being presented for your lordship's law does not in any way conclude that she has committed any corporal punishment to the child. Her submission is so that she has only patted the child and whatever is the punishment she has, your lordship may
Have you
see
seen the video?
I have seen the video, Lord. She has patted the child and she has given punishment, but that does not amount to the corporal punishment is my submission. And she has also written in her explanation how the child was behaving. And yeah, after giving the apology, she has submitted even counsel because your lordship said, I was actually understanding that the matter is coming up for interim there are also guidelines by the NCERT but any kind of such disciplinary acts being taken by the teachers, they should be sent to a counseling. Is the first step. Once a teacher beats a child, and that too when it is not a corporal punishment, they cannot immediately go to, that is not within the jurisdiction, but I am making the submission because the council is trying to project as though the teacher has literally, there are cases, I am not against it. There are cases where the teachers are punishing the children in a way which is not warranted to. My submission is, this is not such case.
All right, I'll consider.
Your lordship may kindly consider in the interest of she is a Telugu teacher, she has no other means of,
doesn't matter which language or which subject she is teaching.
I'm not pressing on Telugu. My submission is she has not committed any offense as contemplated as corporal punishment. What all she has done is she has started the children and she extended her apologies, and there are irregularities. This is a case where the inquiry has to be conducted for the reason that the parent was given the complaint is not examined, only management witness have appeared, and the inquiry was conducted after the school hours, where nobody is there. Filed the presentation stating that the inquiry is violative of principles of natural justice.
In what way is the inquiry violative of principles of natural justice?
For the reason
that it's after the school hours.
After the school hours, and she is not even she is a teacher, she doesn't know of this proceedings. She has appeared there. She felt that by merely apologizing, she will be given a lesser punishment, and she undertakes that she could not do such things. With that impression, she was given. And admittedly, the entire inquiry report does not show any other witness except the management evidence who has appeared and said that, yes, seeing the video, I see that she has imposed a punishment. They do not even have the knowledge whether that amounts to corporal punishment.
All right, I'll consider it. So I have heard the repression itself, not this case.
But if your lordship is going on the issue of corporal punishment, I may be given the opportunity to place necessary material before your lordship.
So may I say one question I should ask? Principle is it good circuit because only one part of the circuit. Lots like that. I leave this.
My submission is principal has power to issue suspension order. I'm not on it. My submission is there are no. I am not challenging.
No, you did say that the appropriate authority has not placed you under suspension. That was first charged by you.
My submission was the principal has issued the suspension order. He has provided for appeal. In the order they have mentioned for appeal. For appeal, she has submitted a representation which the company will receive physically.
All right.
Thereafter,
so you are not saying that the authority who has passed the suspension order has no authority.
I have read the 6 million, wherein it states that only in cases where the charges of criminal nature or criminal offence is concerned, the principal has power to suspend.
All right.
Here is a case where the inquiry is concluded according to the respondent's will.
All right. Day after tomorrow for orders. Next for the next. $230.
May I please
I'm not dealing with corporate punishment at all. Yes.
230 matters. Item was 105, 106, 107. Koteshwar Prasad, Ramarao. Ram Mahadeva, A.K. Jayaprakash Rao.
In item 105, I'm appearing petitioners. I'll submit my arguments. My senior counsel is there.
I'll add subsequent days.
Sorry, I can't hear you.
Item 105, ma'am, appearing for petitioners, my lord.
You are Mr.
Vasudevan, my lord, representing Mr. Avi Koteshwar Prasad.
Acha, you are representing Mr. Avi Koteshwar Prasad. Yes, what do you want to say, sir?
Lord, in 104 and 105, my lord, senior counsel is appearing, my lord. I'll submit, my lord. I'll add subsequent, my lord. Seniors have submitted, sir.
Yes, senior counsel is already here.
Yes.
Yes.
Only thing that next two matters is representing.
Next two.
Yes, three matters are similar.
Yes, 105, 106 and 107. So you are appearing in all the three
All
matters?
the cases I will read the matter.
Okay.
There is an actual difference.
Okay.
Your last meeting 106. Repetition number 8330/2020. Of termination is called in person in these petitions.
Okay. All the three petitioners are
In all the three petitions,
petitioners are different.
the petitioners are different, but the post is common. Now they are working in the cotton, union cotton purchase.
Union Commercial Executives.
Yes.
In the Cotton Corporation of India.
Yes, Cotton Corporation of India. Redesignated as Junior Farmers Executive. Where so far petitioners are concerned that they are graduates. And they post experience minimum qualification of 1 year is in dispute. So that the episode started in October 2014 when the respondent corporation notified the post of junior purchase junior cotton purchasers. A notification came to be issued calling for application. Then we have the qualification prescribed is graduation in any stream, so for that is considered there is no dispute. It is not being much with you. And also 1 year of post qualification experience in any agricultural commodities in reputation organization. In a reputed organization, that is not the public, it may be private organization also.
Where is the notification, sir? Page number?
Yes. Page 194. Page 194. Last shift,
194.
yes, 8330 of 20. The 194 page.
Yes.
Last shift,
Sir, here qualification is BSc Agriculture.
yes, BSc Agriculture from any recognized university with aggregate of 50% or post qualification experience of minimum 1 year of dealing with science graduate or graduate in any science stream or any other science equivalent degree from any recognized university with an aggregate of 50% marks, post qualification experience of minimum 1 year of dealing in any agriculture commodity, reputed organization or expert.
Enterprise.
Yes. So these people who are not into them, they work for more than 2 years in private cotton purchase enterprises. So they are different. There are all public limited companies or private limited companies. That private organization. They submitted post experience qualification and they were selected.
Okay.
On 3/3/2015, they submitted applications. On 13/12. they were appointed, Milord, on 3/3/2015. 3/3/2015, they were appointed. And have been served. Admittedly, Milord, they didn't complete their probation. That means they have not declared. No, 1 year has been elapsed, Milord. The probation has been extended for another year. As on the date of issuance of the show cause notice, Milord, admittedly, they were on probation.
What is the date of the show cause notice?
Yes, on 13/12/2016.
13/12/2016.
Show cause notice is to be issued. Milord, the pivotal ground for issuance of show cause notice is that, Milord, the corporation through their vigilance department, they hold discreet inquiry with the employer of the organization in which the petitioners have worked and submitted experience on it. Milord, so during the course of the discreet inquiry, Milord, which is not made available to the petitioners, it was found that, Milord, the service certificates produced by them were not genuine. So therefore, they secured employment by way of fraud and misrepresentation. That is the substance of the show cause notice.
Yes.
Then, Milord, on 29/12/2016, Milord, a writ petition came to be filed by the petitioner assigning the show cause notice itself. Initially, Milord, it was stayed. Eventually, on 16/12/2022, a writ petition came to be disposed of, directing the petitioner to submit detailed explanation on that the respondents are directed to consider and pass cooperation. Then, Milord, the petitioner submitted detailed explanation running its pages along with all material documents. Milord, showing that, Milord, the sworn affidavit filed by the employer, the salary, vouchers, Milord, particularly the income tax returns, which were submitted by the employer prior to notification, prior to 2014, in which it was depicted that, Milord, these people were being paid salaries. That I will take your much.
So the salaries were not being paid through bank?
Milord,
the salaries were not being
in cash, Milord, because 7,000 in cash was paid. Plus 5,000 towards spouse, Milord, traveling expenses, all the things. Milord, that was reflected in income tax returns. Milord, the employer, he filed it because it is audit. Therefore, they filed, Milord, giving all particulars along with the tax returns. That was audited by the department. That is there in the there. So then, Milord, the final order came to be passed on January 2023. Without considering my explanation, even the documents filed by the petitioner is not even reflected in the show cause, in the final order. Milord, on the face of it, Milord, the impugned order, that is order of termination, shows that, Milord, the order is passed, Milord, basing on the fraud and misrepresentation. They have taken many grounds that, Milord, fraud and misrepresentation. Therefore, Milord, my contention before your lordship, among other things, they shall be taken. Lordship, time is the explanation submitted by at page number 53.
This matter, who is appealing to the respondent? You are appealing. For the Cotton Corporation. You have filed your counter?
Yes, counter.
Okay.
The question of law is that already matter has been carried. This would affect the content of management. No inquiry is required.
No. They didn't file any explanation. They didn't file any document. That was reflected in the order. That was a cryptic order. So far, mine is concerned, Milord.
So some of the candidates have gone to the Supreme Court, up to the Supreme
Yes, similar candidates will not. Only one candidate will not, so one candidate is concerned, he went to the Supreme Court. There the Supreme Court will not, always also there, very clearly called. There he didn't submit any explanation. In support of explanation, he didn't submit any records. So my last CG explanation submitted by me. Suppose if it is reflected in the point order, I can understand. It is application of mind is there. I will just show the explanation and also the interview order so that
Yes.
53 Miller, it starts actually from 54. There are all references and 55.
Up to 61.
Yes, 55 is the factual narration. Yes, 57 without minutes. I submit that the case of employee, both services were terminated from the order show cause notice, which not submit their experience certificate is different from my case, as I have produced my experience certificate and I have denied experience. If there is different and cannot be compared with my case, treating it as same. The cases are different. That is what the Supreme Court order. In this regard, I would like to submit that I have joined in cooperation on 2015 at Junior Cotton Purchaser and reported at branch and performing my duties to the expectations of the superiors without any adverse impact.
Let us come to the portion where they have worked and how the certificates are changed.
Yes.
I think that's the only issue here.
Yes, that's all. That's all with that.
Whether those points have been considered by the authority.
Yes.
That's it.
Yes. In the relevant material, the last.
So what have you stated about your experience certificate and how they have been dealt with by the?
Yes, that's the last minute. After completion of my post-graduation, I got an opportunity from Sri Vijaya Venkateswara Cotton Mills, Lokipadu, as supervisor on temporary basis to supervise purchase and processing operations. That my previous employer has paid a basic salary of 2,000 as per audited accounts for the financial year 2010, 11, 12, 12, 13, which are enclosed for your perusal. My name appears in the salary and wage ledger account and an additional amount of 5,000 per month received for subscription, food traveling expenses in the above respective way. In that way, I have done 10,000 per year as gross salary by cash mode immediately. Not here they are contained in show cause notice that you have stated in the application that you are trying to 12,000. In fact, your employer said 7,000. Because 5,000 it was per. I will take you. Then September 10th, which is mentioned online by applying for the course. Here it was. So respective year. In that way, I have drawn 12,000 per month as gross salary by cash mode during period of next number 10 to 12, which is mentioned in the online application while applying for the course. Subsequently, I appointed as temporary field assistant in Cotton Corporation of India, Hyderabad branch on purely temporary basis and worked for 9 months from 10/12/2012 to 4/9/2013. Reference is enclosed. Thereafter, once again, I opportunity to previous employer, Vijaya Venkateswara Cotton Mills, where I have worked for 1 year period and acknowledge the receipt of salary through cash vouchers and only and basic salary of 7,700 per month credited account financial year 2013-14, 14-15, which are enclosed for your perusal. So and so. There are the details are there. All the audited documents pertaining to my employment, including ledger containing salary and wage for the year, and the cash vouchers as issued by him to me by previous employer, and been filed along with my reply. As regards statutory deductions, EPF, etc., and PT, etc., which are not deducted from my salary in addition, The AP tax on professional traders, foreign and employment tax 1987 clearly exclude the collection of tax from wage earners whose monthly salaries are below 15,000, in accordance with 0% APC code 2030. A being drawing salary of no less than 50,000 per month and a healthy sale act cannot be made applicable to me. Copy of the relevant due is also enclosed. In my case, my initial basic pay is 7,000 with an additional amount of 5,000 towards benefits PhD. Totaling monthly gross salary being 12,000, which is less than 15,000 required for applicable deduct optional tax. And as stated here above, my previous employee, namely, during the period September 10 to 12. And thereafter again, employed for a period of 1 year during September to October 2015, paid basic salary of 7,700 with an additional amount of 6,300, and gross salary of 14,000, which is less than 15,000, required for the applicable deduct of professional tax. Therefore, in my case, professional tax is not attracted. And for non-availability of records regarding professional tax with my previous employer cannot be held against me. And the basis for treating the experience certificate is off. Further, the issue is not that of how much salary paid to me. The issue whether I really worked or not. The salary, how much paid to me, is not important when I really worked in whether I'm getting no salary. That is why I did not show interest in the scheme and just provided fund for not deducted from the document. To make you notice that employees' provident fund and miscellaneous provision section clearly outline the application of the act not only an establishment which is a factory in which there are 20 or more employees. In my case, my previous employer always had an employee less than 20, and the same may be verified with him. Such being the case, the non-availability of records concerning provident fund, which is not applicable as per statute in my case, cannot be held as a basis for issuing the so-called notice.
Sir, you have produced all the documents and all that.
Yes.
Now, the impugned order refers to those documents.
Yes, all documents speak about it. Your last
No, the impugned order also. Yes, come to that.
See the impugned order.
They have referred to all the documents and why they cannot be considered. Yes, yes, yes. Come to page 34.
32, 34.
I think 33 last paragraph will start again.
In this regard, re-verification has been done during the electronic operator of cotton mills in the court. Rajeshekara has informed the managing director of the farm. Rajeshekara has informed during the expiry the documents regarding employment of candidates such as attendance register, family slip, PF and personal check available with it. Further, he informed that salary in the candidates was paid in cash. However, PF and personal check has been done for
no PF
from the salary of the candidate.
No PF, sir. It says no PF or professional.
Or personal tax deduction has been done from the salary of the candidate. He also failed to provide any documents to substantiate employment of the candidate. Previous employer was unable to produce any evidence in support of the employment of the candidate during the investigation. Thus, the previous employer had failed to provide any conclusive evidence to substantiate the employment of the Venkateshwara with them. The fact has revealed that the verification, re-verification of experience certificate issued by so Guntur is established with false and sham. Claim number 1 of the appointment order dated 3/3/2015. Literally, one of the conditions stipulated that you will be placed on probation for a period of 1 year from the date of joining, which may be extended at the discretion of the appointing authority. His probation period was extended from time to time, and till date, Venkateshwara is on probation. Containing the inductions in fact, fraudulent and submissions of the certificate of Venkateshwara, a show-cause notice dated 13/12/2016 was issued to Venkateshwara asking to submit his explanation as to why he should not be terminated of corporation as appointment is why against you. Instead of replying to the show-cause notice, Venkateshwara moved the High Court to Expectation, and the court passed interim stay order dated 22/17. Now in conclusion with the above mentioned order, the registrar has submitted an explanation. The explanation has been pursued carefully and verification can be performed. As per the affidavit submitted by Venkateshwara,
The proprietor.
Guntur is mentioned that in 2015 the CCI vigilance officer as part of the inquiry approached him for seeking information about the requirement of Maypuri Venkateshwara law. At that time we have submitted the following salary slip, salary ledger, income tax returns, so on so. Further on verification it has been found that the above mentioned documents have never been provided by the proprietor of Venkateshwara Mills. At the time of initial verification and investigation, the affidavit submitted by the proprietor of Venkateshwara Mills, Guntur cannot be considered. Further, the copies of documents provided by Venkateshwara following the explanation appears that the set documents created as after copy. There is also disturbance in salary as given in the explanation of the Venkateshwara and the salary ledger provided previous employer. Moreover, the documents submitted by Venkateshwara concerning options of any verifiable status as a proof of the desired experience that the document produced that authenticity cannot be relied upon. Therefore, the explanation submitted by Venkateshwara is not found satisfactory. Further, in accordance with the government of India, as this clearly stated that government servant was not qualified in Gujarat. Is that one thing? The income tax returns have been submitted. How can they say it is fabricated on Shamla?
Where is the income tax? Where is the income tax return where your name is shown?
Yes. It starts from 1.
Where the petitioner's name is shown.
Yes.
Page 92.
Yes, 92 starts with a
26.
Yeah, 98 will have 98 will start. That is for the assessment year 2012 to 30. 98 page.
Yes. 92 also you are the petitioner's name is there.
Previous year.
Previous.
Yes. And this is for previous. Previous. Yes. Then below your last name can be seen 91 dash.
Yes.
3/5/2011 will have first last.
Yes, yes, I have seen that.
I put a medication. Then we have 92. Last item cash paid to right medication. Then 93.
He is the only one receiving 7.
Yes. Then next financial year, next assessment year. There. Now this actually manufactured by me.
Yes.
This is the department. There's EFT that they say EFT is not paid. EFT is exempted. Professional tax is not paid by them. One thing
these service paid by them.
When they are playing with my time mirror, let them inquire. Let them call my employer, call with reports. Let the vigilance officer when they work night at midnight at 12 o'clock, they ask for documents. Then employer say non-availability. And non-availability which has no documents at all. That is all inquiry behind me. None of the documents are supplied to me. The inquiry report, preliminary verification or re-verification is given to me to read all those documents before submitting my explanation. In spite of that, I collected all documents which are in public domain. Most of the documents are submitted to them are in public domain. They can't say that those documents are fabricated. Simply one line word. In the final order, that's one line word. They say that the employment is secured by means of fraud and fraud.
So this is in case of one Mr. Venkatesh. What
Even
about
in
the others?
probation also, there are from TSHC to the Rashmi parents, there are more than half a dozen of the Supreme Court judgments that the recent. That's why the person is assigned in this order is not on three grounds. One is that when the order impugned is based on fraud and misrepresentation, they shall be regulated in case of probationer also. Because that is stigma for future employment. He can't go anywhere now. That is right or wrong, I am not saying, the minute I am not saying. Let there be a fair inquiry. It is revealed without and it is ultimately know that he is. It will not let them that information will take this. 1974 to the SEC, let's say, I think page 887 million from pair of 158. Page 888.
Yes.
The third contention has been elaborately by both sides on the scope and sweep of the background of fruits frame under 309 and pleasure doctrine expressed in Article 310. The two probationers who are friends have considered that what purport to the simple termination of probation on the ground of unsuitability are really and in substance by way of treatment and falling short of the rigorous prescriptions under 312. They are bad. Their complaint is that penal consequences have been visited on them by the impugned order, and since even the probation is protected by Article 311. In such a situation, the court must void these orders. Naturally, the launching pad of the argument in Dhingra case, in a sense, Dhingra in the Magna Carta of the Indian Civil Code, although he has declared reverse and judicial difficulties to be disciplined into one single simple practical formula applicable to termination of probation, freshness and of the service of temporary employees. The judicial search has come the focus on the discovery of the element of punishment in the order passed by government. The proceedings are disciplinary, the rule of the case is attractive, but in the formulation is not was and it doesn't stigmatize the probationer or temporary suspend. The constitutional shield of 311 is unavoidable. In a series of cases, the court was affected with devising a principle of ruling determining this person, where non-punitive termination of probation for unsuitability ends and punitive action for delinquents begin. The OPT showed this court ruled that where the state holds an inquiry and based on complaints of disconduct as temporary suspended, the employer must be presumed to have abandoned his right to designate simpliciter and to have undertaken disciplinary protection, bringing its way the protective operation of 311. The distinguishing mark would therefore appear to be the holding of an inquiry into the complaints of misconduct. Then next, the learned chief justice.
I think if you read para 161, that's sufficient.
The need in this branch of jurisprudence is not so much to reach perfect justice, but to lay down a plain test which the administrator or civil servant can be understood how substantially in obtain without difficulty. A cross between unsuitability and misconduct, this partition do their bounds divide. And over the years in these rulings of this court, the accept has scripted. The canons have been varied and predictability has proved difficult because the way of legal right and share has been baffling. The learned chief justice has in this judgment tackled this problem and explained the rule which must govern the determination of questions to the termination of service of probation can be said to amount to discharge simpliciter and it can be said to amount punishment like retroactive concerned, we are so the judgment of climate is there is a breach of requirements. The orders of termination is that amount to able to pass. You know, once it is ignited,
Yes,
then
requirement.
then we are vested here. Adesha 1992 TSHC, page number 21. Page 35. Page 30. If you will notice on the above issues, the termination of this service of temporary service or non-probation on the basis of adverse effects or on the basis of an assessment that is not satisfactory, punitive in as much as the above facts are merely motive and not foundation. The reason why they are motive is that the assessment is not with the object of finding out any misconduct on the part of the officer, the statement of strong. The organizing case is done only to decide whether it is to be detained or continued with something. The position is not defined even if preliminary inquiry is held because the purpose of preliminary inquiry is if there is diagnosis evidence or materials indicated a regular department of inquiry. Then decided in Chapata says, preliminary inquiry is not to find out misconduct because of the office. If a termination follows without giving a opportunity, it will not be done. Even in a case where the regular department is stated, a charge will be issued only if that is point of time the effort is not, the simple notice of the TSHC cost, the same will not be paid to because the inquiry officer has not recorded evidence or given on the charges. That is what is pending some fee. Then there are page 36, there are 37. 36 in that same page, next page, 38 is page 36 pair. In our view, it is subsequent to the act, and an inquiry of the economic recorded expected. They will clear finding of appellant accepting the plan, given recommended is terminated. So this was done behind the back of the appellant. The managing director of the very next day cannot, in the above circumstances, be stated by any stretch of imagination that the report is preliminary inquiry. His findings are definitive. It is not a preliminary report where some facts are gathered and a recommendation is made for regular departmental inquiry. Where the principal based on the cases referred above, this is an obvious case where the report and its findings are foundation of the admission orders, not merely the motive. Tribunal or citing the HIGHCOURT may measure and treat as preliminary. Here is the report which is said to have been submitted by the Vigilance Department is final. That is taken as granted by the corporation by the terminating by service. Nothing has been elicited independently by the top. And mostly similar to that 2030.
You just point out the relevant portion or you can give the copies. Para number you mentioned, yes, so that I can.
Page 633.
Para number?
35, 37.
Yes.
Page 634. Para 36. Page 639. Para 40. Then we are our HIGHCOURT judgment 20. That is a very cryptic order, but then considered now HIGHCOURT judgment. There are 12 is the relevant. There are 12 is the relevant. Page 157 paragraph.
Yes.
Yes, is also given. Discarded is the motive behind termination.
cases where misconduct constitutes the foundation of offence, an inquiry must proceed such that. Then there are questions. Whereas 5 months. 5 months. Student test. Then we are 2022. Here we learn pair of 49, 45 we learn pair of 45, page 193 pair of 45, 49 and 50. The summon substances that we learn, the inquiry, whether it is external or internal, shall be made available to the judge. It can be, can be a preliminary inquiry can be done. It can be a basis for regular. It can be a basis for terminating the termination. Suppose if the probation is not found satisfactory, you understand, one line order can be passed. Then the petitioner has no say because it doesn't operate in this. Whenever playing the future of the employee, they may say that automated revenue of appeal. But I am saying that the total non-application of my total violation of natural justice. The order itself is per se. The very order, the very initiation of proceedings, the order itself is per se. Then the thing is also mirror. Get the critical point is the action has to be judged in that way only. The constitutional courts are statute prescribed a particular goal. But the actually for anything it has to be done in that way. They can't substitute some other. They can't substitute some other. That is.
Yes. Yes, sir.
Lord, if your lordship permits me.
Yes.
Only one factual submission, my lord, on what my learned senior counsel has submitted. Your lordship may kindly, my lord, take counter affidavit filed by the respondents in WP 8259. That is item 105, my lord.
Okay. Yes.
Your lordship got it, my lord, counter affidavit.
Yes, yes.
My lord, your lordship may kindly, my lord, take page 33 of the counter affidavit. My lord, this is the vigilance, my lord, report.
Page
Which, my lord, 33.
Yes.
The tabular column is given, my lord. On, my lord, verification as well as re-verification is given.
Yes.
Your lordship may kindly take the last tabular column, which is Naresh Rayapati, son of Rayapati Shankar Rao. Your lordship got it, my lord?
Yes, yes. Balaji Jinning will conclude.
Yes, my lord. Your lordship would see the remarks on verification column. Statement of the person issuing experience certificate is taken, but regarding employment of the concerned employee, no document is available. Then, my lord, remarks. The department remarks, I mean respondent remarks. Proprietor of so-and-so Venkateshwar Rao was inquired regarding the employment of the candidate. He stated that the said employee has worked with the firm and documents have been provided. Then, my lord, the final remark, the candidate's candidature has been satisfactorily explained. Lord, this is how, my lord, they have followed. My lord, the experience certificate, my lord, is issued by the, my lord, employer. And, my lord, in similar case, they have accepted the, my lord, certificate also. Wherein, my lord, coming to petitioner's case, they state, my lord, no statutory deductions or documents has not been provided. In the explanation to the show cause notice, all the relevant documents, my lord, insofar as the income tax returns filed by the employer, showing the, my lord, amounts paid to the petitioners were categorically explained to the, my lord, respondents. In spite of the same, my lord, they choose to, my lord, as my lord I have shown, few other persons were also, my lord, considered same way. My lord, even in the eligibility criteria, the experience, my lord, certificate has to be provided. That is all what it is. That is only, my lord, one submission I would have. Rest, my lord, all my senior counsel has submitted to lordship.
All right. Yes. Yes.
Whether inquiry necessary.
Regular inquiry is necessary for terminating their services. And he was still on probation.
Petitioner, there are several petitions who filed the petition. That was not there. Supreme Court perhaps is not for granted within the issue matter. It will also address this thing. Then matter went to Supreme Court, reverse things, saying that the reasons given by the citizen in the district are incorrect and no requirement of inquiry. Necessary. Now, Madam, as far as actual aspects are concerned, I don't want to read again and again. We have quite a detailed counter. And also include the copy of judgments rendered by the SR board, Supreme Board, and Bombay High Court. There, the cotton corporation is employed and the refugees. And there are, as far as Article 3 and 11 is concerned, that it is not applicable to corporations. They are not civil servants.
Okay.
Now, for lordship category 859 829.
Yes, counter.
Okay. Okay, appointment.
Yes, yes.
The judgment rendered by the apex court. The lordship is kind of page 66. Page 66. That's the question.
Yes.
The cotton corporation India.
Yes, of Vignesh.
11% page 72, Madam.
Yes.
Third paragraph. In the present case,
Yes.
the advertisement has clearly indicated the eligibility conditions which contemplated work extension for the prescribed duration. The inquiry conducted by the appellant revealed that the certificate issued in favor of the respondent was completely incorrect and false. The basic condition of eligibility itself does not comply with, and the invalidity went to the root of the matter. It is not a case or a case of any conduct on the part of the employee after the appointment, but invalidity was extended pertaining to the very entitlement and candidature of the respondent. In the circumstances, in our view, the law later by this court, the State Bank of India would not be applicable. It is not even suggested that the respondent was having any documentary evidence to support his case that he had the requisite work experience for more than a year. The document could have been the nature of credit of the document, credit of the amount was salary to bank account. The deduction made by the requisition authority towards its provident fund use or any document. None of those documents are even referred to in the response file on behalf of the respondent. The order determination issued by the appellant thus could not be final. It was stated that the reasoning which is made in the High Court of Bombay, in our view, was the correct understanding of the matter. We therefore allow this appeal, necessary the order passed to the and give them. Now, for Bombay High Court judgment, you will ask this.
Page 80.
Yes. Page 80.
83.
Alert for. There are line
Yes.
where unable to affect the TSI for more than 1 year. The British claimed by the certificate from the employer with respect to tracing back the verification of this claim of which this claim was carried out by the respondent, a public sector government official undertaking by approaching the scope of employer. That employer denied any employer relationship, stated that the employment was by the supervisor of the firm. Initially, there was not a claim of the same employer, and it stated that the employer and the petitioner but paid the salary in cash. That was changed this version and stated that the supervisor employed a petitioner and paid him salary while the person is directly contrary to the person of the said message like sitting and present. It does not say that he employed the petitioner but his firm employed him. He states that he did not pay his salary or money, but the firm employer paid the same. In the light of his contrary the experience certificate is not denied, reliable cannot be faulted. The constitution cannot be relevant for us, appreciated with any other applicant and the response granted. The petitioner report that services, the circumstances, both the order of duty, but the related because of the abatement, and the papers will not like intervene. In a month, but as far as salary is concerned, they have not affected since they are working. Not very good. Now, the judgment of High Court will not be find page 87. Page 87.
Yes.
The character of the page means a large number of but because against that who are professionals on the post of their partner, who are appointed to the year their services of parent and the ground system, they produce the change experience certificate. The order of termination was subject to judicial scrutiny by filing the expedition, and the learned signatures has followed the allowed the expedition. The common order dated 4/1/2017, setting aside the termination order, challenging the debt establishment of the first order from the time when the common order was passed, it was a common high court for the state of Telangana and state of Andhra Pradesh, and our establishment of the Andhra Pradesh High Court, like their
yes,
belonged to the state of Andhra Pradesh was transferred to the state of Andhra Pradesh. The implements of the AP High Court and this specific appeal, thereby the order of the sitting aside the termination was suspended.
so they have reproduced the entire Supreme Court order.
Yes.
And then I think you should come to page 99.
Yes. Now there are so when originally so-called notice was given to them, they did not include anything. They stopped submitting information. They often stayed for more than 7 years. And thereafter, when the transport had submitted extension, and according to the management method, is that subsequently the documents were created for the purpose of getting the employer.
They must have been submitted at the time of joining itself. That is the prerequisite. They have submitted these documents. I've seen the income tax returns. They cannot be fabricated like that.
They have not submitted anything which is required. And therefore, the Supreme Court also said the very initial appointment requisite documents are required.
which have not been submitted.
In the case of Mr. Venkata Krishna, the income tax returns of the company, they are enclosed. From there, I have seen that the salary is paid to this person regularly. It's recorded in the profit and loss account and also the ledger account, and it's properly reflected in the income tax return. Now, how you have disregarded and the reason given by you for disregarding those documents is another thing. I do not know the other cases. In all the other cases also same.
That they are just showing the Supreme Court judgment. I will just read one paragraph of the appraise. It is very few. It is not even suggested that the respondent was having any documentary evidence to support his case that he had the requisite work experience for more than a year. The documents were been in the nature of credit of amounts to a salary. Deductions were made requisite authorities towards provident contribute any such document. None of these documents were even referred to the response file on behalf of. They did not file any document. They did not refer any document. Here, the petitioners, that is not a ratio laid down by the Honorable Supreme. This is a one line order, repeat order, basing on.
So in all the cases, no, in all the 1 minute, sir, I'm asking you a factual question. In all the 3 matters, you have filed the documents such as income tax returns.
Yes. There are a written representation, a detailed representation, and along with all recorded. Including GOs also. Regarding provident fund, correctional tax, entire documents are placed to be. Why are they scared to conduct a civil inquiry? Because they say all these things, they say we have so far notice issued. They came to this honorable court straight away. Is it a sin committed by them? They must have all those things in mind.
Second time, first time so far notice. Final order of part they filed the present expedition. Transport is not granted any order. How bad of the herd reserved for judgment after 3 months it was released.
All right.
And even according to the service regulation, there is statutory provided they did not avail it.
What is provided? Appeal.
Appeal
provision.
And by humble submission, we are given details, submitted details counter to the
yes.
petition, all the petition. And also includes a copy of the general with textbook, Bombay. So all these cases were demonstrated that the teachers did not obtain the employment in a free and fair manner. Therefore, they do not deserve a employment.
All right. That's all? Yes.
Where there is a violation, where the order is per se illegal, all those circumstances, I need not invoke or just me, latest judgment, that is based on here judgment state from ultimate
Yes, third result.
Also matters. Item number 10, P.V. Krishna, Chief of Services.
Yes.
The criminal case registered a distribution.
now that legal petition committee check. And that is pending. Subsequently, charge memo was issued on the same issue. Deputy petitioner suspension and 18%. But against the suspension order, he approached this court. This order court by order dated 19/9/2022 directed to review the order of suspension and 66. Thus, they are not applied to the charge. I filed contempt case. Then, after seeing notice in contempt case, where the standing counsel brought the notice, the court rejected reinstated. Then, I found out that was not complied within the stipulated other group, they started. There, they got reduced against me and directed the inquiry officer to complete the inquiry within a short period, and inquiry officer without giving opportunity after some inquiry. But here is same set of facts, same issue. Similar case is pending. So whether Milad she committed suicide because of my harassment or drill master's action in popularizing humiliating her by stating making allegations against the petitioner and deceased teacher. My contention is that he made bad propaganda against her. She got humiliation and committed suicide. That is the case before the trial. Now they wanted to initiate department proceedings and but the law is something extremely state. But it's a criminal nature, even if not other things. Suppose a murder case, case will be decided by the trial court, not the NPA. And this is just like there is nothing.
In the morning, he was pointing out that the charge sheet is yet to be filed in the criminal case. So the criminal case may not be concluded in the very near future.
It's on the criminal case. Okay, I will proceed. Here also, Rashmi kindly take the appointment of inquiry officer, page number 53. 53. 49.
14/8/23.
14/8/2023. And after taking notice, I made a representation of 22/8/2023, seeking that time.
Yes.
But without giving time, the inquiry officer submitted ex parte report. Give opportunity. The Sanagud court order, they are not implemented within the time. They have wanted some more time. I asked 10 days time. Rashmi kindly take page number 57.
So the inquiry is also completed.
The inquiry ex parte.
Ex parte.
Nothing is there.
After that, nothing has happened. After the inquiry report.
Yes, 53. Is the Rashmi to get this 14/8/2023. Because he got reduced against me for persuading contempt. There are 54 Rashmi. Further, A. Pratusha Regional Coordinator TSWRIC, Regional was appointed president of the requested to attend the inquiry on 23/8/22 office. The relevant records available in the inquiry. Then 55, I saw time.
Yes.
They are not given communicated certificate. Yes. Because the head of the institution directed the Rural Authority to complete the inquiry and submit. They will do it. That's it.
When you presented the report is fine. Including where of the where of the number 70. How will what is this even value for the explanation? This is the same. You might have not been the way. For the explanation.
All right, get your instructions and file counter. In the meantime, don't take any coercive steps. Yes. What is before admission? And means that there should be, the respondents are directed not to take any courses steps in the petition. Courses.
Pass out my item of 59, PV Krishna, stay there, Controlling Smart, Pankaj Reddy.
Yes.
The petitioner, major punishment of not firstly, that would not be already to the people. Must be anything, you should not.
The interim order granted. Passed without recording any reasons and without specifying as to what is the public interest involved as required. Because the petitioner is paid for and then the receipt. Yes.
Page number 131 that
They are appearing for the which respondents?
1, 2.
Who is appearing for? Respondent number 4. Yes. Yes. What is the role of respondent number 4 here?
Like he is the officer who issued the order executed master things. Intentionally did it.
Oh. Yes, this is compulsory punishment of compulsory retirement. For what charges are what?
Charges were issued, no charges were stayed by the assembly. That is pending. So, the matter is pending before the must be taken. Disciplinary proceedings initiated.
Where is the charge memo?
Yes. Charge
26.
26.
Irregularities in the purchase of map with of papers. Also displayed carelessness in requisitions and performance in examinations and diploma courses. Okay.
Again,
Now-
another charge memo 98. Self-payment. 98. Then we have the
98 is only a letter.
yes,
97.
inquiry report submitted on 2040-2050, page number 99.
Okay.
Then the entire thing for the suspended, page number 133 will have to take
133.
Reason not possible.
Yes.
Democracy, as seen from the orders, no inquiry has not taken in bona fide manner, and the decision was not taken by Mr. Happy. Having regard to the same, there is an interim suspension has paid for. The entire suspension, department was it. And when the matter pending before the Sandhurst court, now we are decided that this kind of thing. Without any reason, nothing but as if he is the president.
Where is it? There is the interim order of
Page number 135. If president sacked the government Supreme Court consultation, you should do reasons. In 2010, government change will not enter.
back from the option. Yes.
Now, these are the courts were suspended.
Yes.
That kindly say on 135 retirement is very important for retirement. It's not a safety measure, my lord, there is no punishment at all, not called punishment.
He retired on attaining the age of superannuation.
After getting charged, my lord.
No, he retired on attaining the age of superannuation. Then
his service not required, my lord, there is a public interest in moral and duties, my lord.
then that is a punishment. If you are saying moral turpitude and all those things, then no, you should say when you are retiring a person, either he retires on attaining the age of superannuation, or you pass an order of retirement on some ground. What is the ground on which you have passed this order of retirement?
That is reason, my lord, considering the entire ending of the service record, the confidential record, my lord, is service not required to the public interest. That is, my lord, the training committee has started 123.
So
my
where?
lord, is reviewed, service not up to the mark, service no more required, my lord. Can you see my photo, my lord, page number 49?
What is the age of the petitioner?
About
2 years. So once this court has granted stay of all further proceedings, and suspension of all proceedings, how can you proceed further?
my lord, reviewing the employee capability of service, it not come under the any charge. There is not come under the any charge or any punishment. It's considering the entire service. My lord, appointing authority, disciplinary authority has power, absolute power, by the Supreme Court stated in several judgments. If we are also have absolute power, my lord, to the employee.
So under which provision have you retired the petitioner?
Yes,
from
Fundamental
service?
Rights 56 J says, my lord, my counter, my lord, page number 49, can you see, my lord? The para number 2, my lord. Retiring, compulsory retiring from other charges different with the retirement of the petitioner.
No, where is this?
Page number 49, my lord, para
49.
para two. The objective of fundamental rule 56 JI and rule 46, 48 of the CCS Special Rule 1972. It is strengthen administrative machinery by developing responsible and efficient administration at all levels and to achieve efficiency, economy, and speedy in the disposal of the government functions. It is classified that premature retirement of the government service under these rules is not a penalty. It is distinct from compulsory retirement, which is one of the prescribed penalty under CCS and CCA rules 1965. My lord, next page, my lord. Petitioner fall under, my lord, 3.2. The appropriate authority shall, if it is of the opinion that it is in the public interest, so to do, have an absolute right to retire any government servant by giving him notice of not less than 3 months in writing or 3 months pay and allowing the issue of such notice. And kindly see, my lord.
Read further.
Number 1, yes. Thus, if it is a group A or group B service or posting substantive, quasi-permanent or temporary capacity and entered government service before it attaining the age of 35 years and he has attained the age of 50 years. In any other case, after he has attained the age of 55 years.
So here he falls within that government one.
Yes, yes. Frequently, fundamental when notwithstanding anything contained in class 1, the appropriate authority shall, if it is in opinion that it is in the public interest to do so, have the absolute right to retire a government servant in group B service or post who is not governed by any pension rules. After he has completed 30 years service by giving him notice of not less than 3 months in writing or 3 months pay and allowing the issue of such notice. He is entitled everything minor except to service. Kindly see page number 113. The committee carried is 123 meeting without minor in service of now. NIEPIG Executive Council in its 123 meeting held on NIEPI in Secunderabad on 22/10/2015 has taken the following decision. The proposal for reviewing the performance of the group PMC staff members in NIEPI under Fundamental 56J under Rule 48 EC approved the recommendation of the periodic review committee consisted by the Institute of for reviewing the performance of the group PMC. It is basically performance.
So now the petitioner falls under which category of employees?
B.
He's under B.
Yes. Staff members of the institute under the fundamental group approve take a necessary action as per the recommendation of the committee publishing. I learned here establishing the what are of the petitioner, but categorical statement my lord. I put up with that page number 9, my lord. Roman paragraph 5. He forged the stamp and signature of the superior officer while he is under suspension. While Roman number 5 is also submitted the petition filed under suspension on 12/6/2019, alleged to have forged the official stamp and for applicated the official document and submitted the same to the passport authorities for obtaining Indian passport and acted in a manner which is unbecoming of government service. On submission of the factual information, the passport authorities have issued a notice dated so and so to the petition to surrender his passport within 7 days. The institute has also issued a so-called notice so and so to the petition. The review committee has also gone through the available SCR and APR and other service records and found that the petition is having doubtful integrity and efficiency, and also found that the services are no longer useful to the institute and accordingly recommended for retired the petitioner permanently for the pilot. Earlier also, the petitioner did not challenge pilot. The response authorities are issued censure also. Basing on his aptitude, given a warning at page number 59. Article 1 last two now therefore having regard to the findings of the inquiry officer as stated above and taking into consideration all other facts regarding the circumstances of the case.
Page number
59. After second paragraph. Now therefore having regard to the findings of the inquiry officer as stated above and taking into consideration other facts regarding the circumstances of the case, the undersigned is satisfied that good and sufficient reason exists for imposing on the petitioner LDC typist the penalty of censure. The entire service is doubtful matter.
So then that means you are enforcing this as a punishment.
Not a punishment.
Yes. Now you are mentioning all these charges against him. Then you have to give him an opportunity. How can you retire him? And this is nothing but punishment. And once the court has already granted stay of all for the proceedings, how can you issue this?
The stay of proceedings granted under the subsequent cases. That is not in the consideration of the petitioner's integrity and demand of service matter. The Honorable Supreme Court also, my lord, confirmed that absolute matter the employer has absolute power. Employees service are not required. Details from service matter can be number 98. My lord, page number 50. Extracted my lord, page number 54. Reviewing the employee service to the efficiency, my lord, not required any notice. My lord, para 11, important Supreme Court. This is memorandum, my lord. These rules have been followed by the.
Now, where is that review of the petitioner's case? The EC has reviewed.
Yes.
Where is that report? Then?
Confidential report. I will verify another. I also want to see that.
Definitely, if it is a punishment, then you have to give him an opportunity and then proceed. And if it is on the ground on which you have initiated proceedings which have been stayed by this court, then you could not have proceeded at all on the very same grounds. Then that will amount to contempt. Once the interim, there is an interim suspension of all further proceedings by this court, how can you proceed and then issue premature retirement to the petitioner?
Why Retirement is not a punishment, my lord.
So show me that report. What performance you have considered the review committee?
Department are reviewed, my lord.
So how many of them have you retired?
That is, 27 persons are reviewed, my lord.
You have reviewed 27 persons. And what are the criteria that you have taken into consideration in respect of all the persons? So that's what I want to know, all those things. Find that review report.
We'll ask the department.
If you are saying that, it's only review of his performance and it's not only the petitioner, but several others have been reviewed, then what is the criteria that you have taken into consideration? If even one of the ground is that, the charges against the petitioner which have been suspended by this court, you could not have proceeded at all in the case of the petitioner.
Earlier, charges are found minor, not good. That can power minor, even though the received was charge memo minor, basing on integrity, like itself was very not true, but some other things, who are not true, other things. Warrant to issue a charge memo and the delinquent officer.
Starting point.
Pass out matter, item number 76, Chandra Shankar, Ram Gopal, Chief Bus Services.
Yes, TSPSC. Have you received the instructions?
Your chair. If you take you list on vacancies out there.
Unfilled. Make a representation, then come back. I'll post it after a week or so. And then we can. Next week. Same list.
Item number 91, Hanuman Rao, Chief Bus Services, Kishore Rao.
No representation we have the petitioner. Next week.
Item number 92, Arvind, GP Basal.
Yes.
This is by my application. I have seen application. But before that, I would like to not press on the interim orders and argue on the final.
If you are impleading them, then a notice will have to go, or first it has to be allowed. Notice will have to go and it will come. Interim application, you are not pressing. Implementation raleda. IA is not pressed. IA 1.
Not pressed.
That is what Internet Council for Regulation submitted that. It's not pressing the interim application for stay, that is IA 1. It is accordingly. The implementation is out. It is not yet listed today. Implied petition is not there. So tomorrow further. First, let us inflate, then I'll order notice in both together. Notice also is not ordered yet.
Item number 93, Lakshman Narasimha, Balakrishna, Chief of Service, Chief of Information Technology.
Being qualified but pension. I granted up to 33 years, but it's one short of 5 months. They counted less than certificate. Therefore, right, it is different plan. My intention is complete central is temporary capacity also will have been counted. This is what will a Indian make judgment. I pass on the judgment to the lodge. Basically, but this is GP. Accountant general, they are central to your data. Just we are discussing. Accountant general is more powerful than the state. They prefer to go by what the state says. And this for 30, possible 2000 is
one next week.
If also counseling is not prepared, so you will also kind enough to post it this week. These are covered matter, request of only just because I gave a judgment in the group pension is 70.
Tomorrow, if you find any difficulty, I adjust. Day after. Day after.
99 months. Bill number 95, my lord. It's also a pension case. In 97 years, 97 years compulsorily retired. The scheme has been announced in 2026 to matter.
It will be reaching tomorrow, don't worry. They'll all be coming up tomorrow. Today we have already reached 92, it's over. Tomorrow this yes, this list will continue. Huh? No, they'll be coming up in the list only. Tomorrow your matter will be in the daily list 3 or 4, that's it.